كده يعني هو الحوار ده. Good morning to all. This hearing is now called to order. I am Don Carrington, hearing chairman of this panel. Also on the panel are Dr. Anki Scott Joseph, Commissioner, Ms. Juan Martinez, Commissioner,
And also,
Mr. John
it's going to
Griffith,
talk about
Commissioner,
financing options
Mr.
revenue. And then
Samuel
we're going to have a
Wallison,
Q&A
Commissioner.
session. We're going to have some break.
Commission is
One
also
break, sorry, in the middle.
represented here today
After 90
by
minutes.
Dr. Marsha Abeli Aikachi, the Chief Executive
Presentation.
Officer, Mr.
We're going
Kevin
to have
Webster,
a 10,
General
15,
Legal
20 minutes break.
Counsel and the
We're
Commission
going to go.
Secretary,
And then we're going to
Mr.
go
Brian Reese,
to our second
Director of Utility Regulation,
session.
Mr. Ulrich
Another
Stark,
90 minutes.
KC,
And at the end, we're going
External
to
Counsel,
do a small round
Mr.
of
Roger
feedback
Ford, KC,
on your
External
side.
Counsel,
And as
and
well as
GDS
Q&A
Associates Consultants. Our stenographer today is Ms. Claudia Corbin. I would now ask Ms.
Perfect.
Belinda
As I said,
Wood
this
to
is,
swear in Ms. Corbin.
as we already presented in the introductory session, we are developing, we RENAC are developing a training cooperation with ICE and International Soil Alliance, funded by European Union.
Or do you affirm?
And the name of this project is developing and delivering trainings on mini-grid and storage. In those three regions, where ISA is active, has members, which are Latin America and the Caribbean, Africa, and the region of Asia Pacific. So, as I said, there were two main parts of this training. The first one is the online training of photovoltaic diesel hybrid systems, and now this virtual training of photovoltaic microgrid systems. And it all belongs to the capacity building and expertise development for storage and microgrid trainers.
To enter appearances.
I'm going to present our expert. He's going to present himself as well later.
Ramon Aline
be working
of
with
Clark
him.
Gittins
Renac
Pharma,
works with
with
Lensus
Mr. Kevin
Hoffman,
Boyce,
and we're really glad to
Mr.
be working with him
Rene
again.
Butcher.
Aslan is employed in
Applicant is
Lensus
represented
since
by the Managing
2017 after
Director
being
and
graduate
Associated
power system engineer from
Managers
Clausthal University of
this side
Technology
of the
in
table.
Germany. He has a strong background in technical and
Thank
financial
you. I
aspects
now
of
invite
decentralized
the
energy
conveners,
systems,
the
and
Barbados Renewable Energy Association,
specialized in digitalization in the mini-grid sector at all.
The Energy Division, by letter dated August 25, 2023, has indicated that it is unavailable to participate in this hearing. Intervener Team Tricia Watson and David Simpson.
Good morning. I am here, Tricia Watson, obviously on behalf of the team. I am accompanied by co-intervener, Mr. David Simpson, and also assisting me is Ms. Jamila Eastman, attorney at law.
Thank you. Mr. Wendt.
Good morning, Mr. Chairman and panel. I'm Ricky Wendt. Assisting me would be Dr. Ali Alfar, Mr. Adlai Stevenson, and Mr. Tony Gibbs. Mr. Alfar will be online and see he's overseas, and my other interveners will join us later. Thank you very much.
The Barbados Sustainable Energy Cooperative Limited.
Good morning to everyone. I'm Trevor Brown, and I expect to be joined by my partner, Mr. Hattie Haynes, at some time during the day.
Thank you, Ms. Lieutenant Colonel Brown. The Business Development Division. The Barbados Association of Retired Persons.
Good morning. My name is Douglas Skeet, and I'm representing the Barbados Association of Retired Persons.
We did note that the Barbados Renewable Energy Association indicate that they will online. Could we ask them to put in their appearance? The Barbados Renewable Energy Association.
Good morning, Robert Goodrich from Barbados Renewable Energy, participating online.
Okay. Thank you, Mr. Goodrich. I note, Mr. Douglas Frederick, Public Counsel, your
Good morning, the Honorable Commission and its panel. My name is Douglas Frederick, and with me is Ms. Danielle Cox, Attorney at Law, here on behalf of the Public Counsel. And we will be assisting the Barbados Association of Retired Persons, if it so pleases the Commission.
So you're not assisting the Business Development Division?
Yes, of course, but I was hoping that a representative would be here, but we are as well assisting them as well.
Okay.
Thank you very much.
Okay. In the matter of the Utility Regulations Act, Cap 282 of the Laws of Barbados, and in the matter of the Utility Regulations Procedural Rules as amended, and in the matter of the application by the Barbados Light and Power Company Limited for a review of electricity rates, and in the matter of the decision of the Fair Trading Commission issued February 15, 2023. On March 7, 2023, in accordance with Rules 8, 53, 54, and 55 of the URPR, the Barbados Light and Power Company Limited, the applicant, filed and served a notice of motion to review and vary the Commission's decision dated February 15, 2023. The applicant also requested a stay of certain orders made by the Commission in its decision. In accordance with Rule 4 of the rules, the Commission issued Procedural Directive Number 1 on March 16, 2023 to the applicant and the interveners. The procedural directions invited all interveners to make written submissions in support or against the granting of the stay and permitted the applicant to respond to those submissions. Interveners were also given the opportunity to respond in writing to the substantive motion, and the applicant was permitted to reply. On May 12, 2023, the Commission issued its decision on the request for a stay and ordered that paragraphs 400, 401, 404, 405, and 407 of the February 15th decision be stayed until the determination of the applicant's motion for review and variation. On May 24, 2023, the Commission issued Procedural Directions Number 2 to all parties and advised that in accordance with Rule 36, the motion for review and variation will be disposed of by the way of an oral hearing set down for 3 consecutive business days commencing Wednesday, June 14, 2023, and concluding Friday, June 16, 2023. By notice of motion dated and filed on June 5, 2023, the applicant requested that the Commission amend its Procedural Directions Number 2 and adjourn the consolidated hearing that had been set down for June 14th to 16th on the determination of the threshold test and the motion for review. On June 30th, 2023, the Commission issued its decision on the motion to adjourn and fix new dates of August 28th, 29th, and 30th for the hearing of the motion for review and variation. On July 26, 2023, the Commission issued its amended Procedural Directions Number 2 and stipulated that the hearing of this motion for review and variation would be heard as follows. The applicant will be given 45 minutes to present on the threshold question and the motion. Interveners will be permitted 45 minutes each to respond to the threshold question and the motion in the following order: the Barbados Renewable Energy Association, the Energy Division not in attendance today, Ms. Tricia Watson and Mr. David Simpson, Mr. Kenneth Wynn, the Barbados Sustainable Energy Cooperative Society Limited, the Business Development Division, and the Barbados Association of Retired Persons. The applicant will be permitted 45 minutes to reply to the intervener's submission on the threshold question and the motion. Following the submissions of all parties, the Commission shall adjourn the hearing to consider and prepare its decision. No further oral or written submissions will be permitted. The Commission's decision shall be based upon the consideration of the whole of the record of the material properly before the Commission. During this hearing, the Commission and the Commission's counsel may, at any time, pose questions to the applicant or the interveners and their representatives for clarification of anything said during the hearing, submitted in writing for the purposes of the hearing or generally. Kindly note that this hearing is limited only to the threshold question and the grounds raised for the review and variation in the motion. The hearing is not an opportunity to re-argue the case or address matters outside of the motion. I now invite the applicant to present on the threshold question and the motion.
Thank you, Chair. By amended procedural directions dated 26 July 2023, this Commission directed, in accordance with Rule 55.3 of the Utility Regulations Procedural Rules, a consolidated hearing to decide both the threshold question and the substantive motion. As it relates to whether this motion meets the threshold test of whether the subject order should be reviewed, this Commission, in its storage decision of April 23, 2019, succinctly stated the criteria. Those being grounds identifiable, material and relevant to the decision made, and a prima facie basis that there's enough substance to the issues raised. Condition 1 has been clearly met with significant grounds identified at paragraph 23 of the filing. Condition 2, each ground relates to a specific element of the decision under review and is therefore clearly relevant to the decision. The materiality element I would compare to the question of a serious issue to be tried. This Commission has already determined that to be the case when ruling on the stay application. Condition 3, again, the Commission's ruling on the issue of the stay will indicate that prima facie basis has been raised for the grounds filed. Due to the limited time, the applicant confirms and adopts its written submissions filed on March 7, 2023, and we will use this presentation to augment and crystallize certain grounds of review. The first being that the Commission acted in excess of its jurisdiction and therefore ultra-virus by directing the applicant to take certain actions regarding the SIF when it had no jurisdiction to do so, and had previously acknowledged that it has no jurisdiction under its enabling legislation to oversee the SIF. There are two jurisdictional failings on the part of the Commission as it relates to the self-insurance fund. First, the Commission has no jurisdiction to oversee the operation of the fund or the actions of its trustees regarding the assets held within. By letters dated April 19, 2016 and May 17, 2016 to the Commission, the applicant proactively notified the Commission of its intended withdrawal and distribution of funds. In response to this correspondence, the Commission then expressly confirmed that it has no jurisdiction in the matter of the fund, and specifically over the management of assets entrusted to the fund in a letter to the applicant dated May 19, 2016. Secondly, it is a well-established fact relative to the practice of statutory interpretation that a statutory entity must act within the four corners of its enabling legislation. Any actions outside the general, specific, or incidental powers of the Commission are ultra vires its powers. The applicant recognizes incidental powers of the Commission, which are ancillary to its specific and general powers of rate making, and these are guaranteed by the Interpretation Act and common law. However, the applicant contends that the incidental powers granted do not grant the Commission the power to make the pronouncements it has in the decision regarding the fund. Section 19.3 of the Interpretation Act says, where an enactment empowers any person or authority to do any act or thing, all such powers shall deem to be also given as are reasonably necessary to enable that person or authority to do that thing or incidental to the doing thereof. The applicant contends that a requirement to create a regulatory liability account in relation to the fund, as indicated in the decision, is not reasonably necessary or incidental to the rate-making powers of the Commission. We refer the Commission to the decision of the majority of the Supreme Court of Canada in ATCO Gas Pipelines Limited versus Alberta, a 2006 decision, which dealt with a similar question, whether the regulator had jurisdiction to allocate portions of profits of the sale of gas utilities assets. At paragraph 78, the dicta states, in my view, allowing the board to confiscate the net gain of the sale under the pretense of protecting rate-paying customers and acting in the public interest would be a serious misconception of the powers of the board to approve a sale. To do so would completely disregard the economic rationale of rate setting. As I explained earlier in these reasons, such an attempt by the board to appropriate a utility's excess net revenues for ratepayers would be highly sophisticated opportunism and would in the end simply increase the utility's capital costs. At the risk of repeating myself, a public utility is first and foremost a private business venture, which has the goal of making profits. This is not contrary to the legislative scheme, even though the regulatory compact modifies the normal principles of economics with various restrictions explicitly provided for in various enabling statutes. None of the three statutes applicable provides the board with the power to allocate the proceeds and therefore affect the property interests of the public utility. And that is the consequence of the decision under review. In my presentation to this commission at the rate hearing, I said, as articulated in oral evidence, consumers, that is the ratepayers, pay for a service. Once they receive the service, they no longer have proprietary interest or ownership of the monies paid. To take a position that customers retain ownership of funds after having paid for the service ignores fundamental principles relating to ownership, consideration, and transfer of value. If customers can receive the service and retain ownership of the monies used to pay for the service, then business operations and economic systems will quickly fail as unsustainable. The Commission's response to that argument is found at paragraph 229 of the decision. BLPC argues that once customers receive electric service, they no longer have proprietary interest or ownership of the monies paid for the electric service. However, in the case of the SIF, the future restoration of T&D assets in response to a catastrophic event is directly related to the electricity service to be provided. Accordingly, the reserves of the SIF have not been used to provide an electric service to the customers. That was the reasoning of the Commission. That finding is directly contradicted by the findings in ATCO, which are in sync with the position of the applicant at the rate hearing. At paragraph 68, the Justice states, thus can it be said, as alleged by the city, that the customers have a property interest in the utility? Absolutely not. That cannot be so, as it would mean that fundamental principles of corporate law would be distorted. At paragraph 69, they debunk the Commission's finding at 223 as it relates to the continued investment in a future service. There it stated, the property in question is as fully the private property of the owner of the utility as any asset it owns. Deployment of the asset in utility service does not create or transfer any legal or equitable rights in that property for ratepayers. Absent any such interest, any taking such as ordered by the board is confiscatory. The incorrect premise reflected in the decision is that because self-insurance funds may be utilized in restoration of T&D assets in the future, it is therefore tied to providing electric service and therefore creates customer interest. ATCO debunks that. In the clear words at paragraph 69, the justice says, I fully adopt this conclusion. The board misdirected itself by confusing the interests of customers in obtaining safe and efficient utility service with an interest in the underlying assets owned only by the utility. The Commission violated an important principle of regulatory rate making by engaging in retroactive rate making outside of legally established principles about when this is appropriate. And that obviously brings me to the major concern of the applicant in these filings, and that relates to the element of retroactive rate making in terms of the decision as given. And that retroactive rate-making concept permeates the decision in multiple ways and will be referenced later in this presentation. In seeking to justify its departure from this rule, the Commission references the authority of Capital Power Corporation. However, this authority is quite distinguishable from the circumstances of the rate review because in that decision, there was a finding that the lost line charges were unlawful and in contravention of the Electric Utilities Act. And this finding of unlawfulness was not challenged prior to the regulator granting relief. In the present circumstances, there has been no finding of unlawfulness under the Utilities Act or any of the enabling legislations in relation to the actions of the applicant as it related to the self-insurance fund. Further, even though the court in Capital accepted that the exceptions to the rule against retroactivity are not closed, it placed its decision within the established exceptions. That has not occurred here. The Commission has not similarly made such an attempt. Rather, it identifies policy without explaining its decision to extend those exceptions. In fact, the universality of the rule against retroactive rate making is referenced in the same ATCO case, where there, like in the instant circumstance, there was an effort to enforce a sanction for past conduct in an effort to safeguard consumer interests. At paragraph 71, the justice says, there is no power granted in the various statutes for the board to execute such a refund in respect of an erroneous perception of past overcompensation. It is well established throughout the various provinces that utilities boards do not have the authority to retroactively change rates. But more importantly, it cannot even be said that there was overcompensation. The rate setting process is a speculative procedure in which both the ratepayers and the shareholders jointly carry their share of the risk related to the business of the utility. A considered failing in the decision, the applicant will argue, is the lack of reasons, written reasons, or insufficient reasons to found the basis to conclude that it considered or properly considered the evidence submitted on the matter of its prior referral of the withdrawal from the SIF to the Commission. It is either the case that the Commission improperly considered evidence regarding the movements of funds into and out of the fund, or failed to properly consider evidence proffered by the applicant, which demonstrated not only the Commission's confirmation of its lack of jurisdiction, but also that the applicant had obtained the approval of the regulators who were legally and properly empowered to regulate the fund. The lack of reasons to explain the non-assessment of critical evidence, such as the correspondence. And the matter is that the correspondence and its import was never explained or defended or analyzed in the decision. And that correspondence evidenced the applicant's good faith attempt to ensure compliance with all regulatory obligations. It's critical because in the absence of the reasons, the applicant was entitled to rely on the principle of regulatory certainty, another issue that will be referenced later, and legitimately expect that the Commission would not act capriciously to its detriment. And that brings us to the ground related to the reasonable and/or legitimate expectation that the 99.5 million withdrawal from the fund, of which 15 million was paid to the government of Barbados, would not be treated capriciously by the Commission based on its prior representation. The dicta of Cornelius J. and Harrison et al. Versus Permanent Secretary, Division of Energy and Telecommunications, 2014 decision, provides the following overview of the general principles of legitimate expectation. First of all, it is clear that, as mentioned above, the correct public authority must be identified. That is not in dispute here. Secondly, there must be cogent evidence as to what the public authority, whether by practice or promise, committed itself to. Again, not in dispute. We have the letters. The policy or promise must be clear, unambiguous, and unqualified. Again, met. Thirdly, the claimant must establish whether the authority has acted or proposes to act unlawfully in relation to that commitment. And it is our argument that that is the impact of this decision. The applicant submits that it had a legitimate expectation based on written confirmations and approvals obtained from the Commission, the Financial Services Commission, and the Central Bank of Barbados, that the Commission would not 6.5 years after the fact rewrite history and use unconnected rate-making exercise to recharacterize that withdrawal as a regulatory liability to be repaid. The applicant openly notified the Commission, the FSC, and the Central Bank of Barbados of its intention. After $15 million in tax was paid to the government of Barbados, it was delivered to the beneficiary. At that time, none of the regulators raised any objections to the applicant's removal of the funds, and the Commission determined that it did not have jurisdiction in relation to the general administration of the self-insurance fund. In its May 19th letter, the Commission, in clear, unambiguous, and unqualified manner, stated, "The Commission confirms that the Barbados Light and Power Company Limited does not require approval from the Commission for the proposed changes to be made to the funding level of the BLPC Self-Insurance Fund, which was formally established under the Insurance Act of Barbados in 1998. The Commission's representation was relied upon by the applicant, but also by the Central Bank of Barbados in its approval granted by letter dated June 15th, which itself was clear, unambiguous, and unqualified. The Commission, through its February 15th, 2023 decision, has not only retroactively gone back to reverse its position, but has gone a step further, and in its decision has justified the retroactive nature of its decision by impugning that the applicant actions in relation of the removal of funds from the SIF were improper, imprudent, or wrongful, in spite of the applicant having sought approval. The legitimate expectation argument is clear, but this aspect of the decision also offends a critical principle of estoppel. The Commission is estopped from treating the withdrawal as a rate-based deduction. In Lever Finance Limited versus Westminster City London Borough Council, Lord Denning, as MR as he then was, in delivering his judgment, stated that a public authority is bound by representations made by its officers as follows. If an officer acting within the scope of his ostensible authority makes a representation on which other acts, then a public authority may be bound by it, just as much as a private concern would be. A good instance is the recent decision of the court in Wells versus Minister of Housing. It was proved in that case that it was the practice of planning authorities acting through their officers to tell applicants whether or not planning permission was necessary, very akin to the present situation. A letter was written by the council engineer telling the applicants that no permission was necessary. The applicants acted on it. It was held that the planning authority could not go back on it. The Commission's decision to utilize the rate review process to retrospectively reopen items that have been previously determined by the Commission and acted upon by the applicant in a contrary manner that is punitive to the applicant, its investors, and other stakeholders is unlawful. It has undermined the confidence of investors, thereby affecting the applicant's ability to raise capital to fund investment or maintain existing assets in such condition as to enable it to provide service. No investor puts money in a company where they can take decisions after seeking regulatory approval, getting the regulatory approval, and then 6 years later told, I am about to slap you on your wrist. It was wrong. Investors do not put their funds up to that type of risk. It is arguable that there's a questionable reasoning by the Commission in relation to these findings at paragraph 221 of its decision. The Commission correctly states no funds were paid into the fund by Emera and correctly states that the applicant is the beneficiary of the trust. The trust itself, in paragraph 5, states that the monies may be disposed of as provided in the regulations. The regulations themselves, at 8.2, indicate that monies withdrawn shall be subject to corporate tax. So both the trust and the statute contemplate the withdrawal of funds. Where the Commission makes its fundamental mistake is conflating BLPC's decision to pay out the withdrawal funds as dividends with some action or right of BLPC's shareholder. Emera is not party to this. This was the right of BLPC's board when considering the legitimate fact that a buildup in SIF funds was substantially achieved by shareholders deferring previous dividends. There was never an argument for retention by the shareholder as alleged in paragraph 224 of the decision. By focusing on the shareholder, the Commission fell into a jurisdictional trap when it states at paragraph 225. The Commission notes that the regulation of insurance entities is the purview of the Financial Services Commission. However, it is clearly within its jurisdiction to regulate the rate recoveries for monies that support insurance and a SIF, as well as the rate treatments of monies removed from the SIF for non-utility purposes. It is correct that it has jurisdiction to regulate rate recoveries for monies that support insurance and a self-insurance fund. It is totally incorrect when it believes it has jurisdiction over monies removed from the fund legally and delivered to a beneficiary. These funds become the asset of the utility, and as I clearly indicated in my submissions during the rate review, and more harshly enunciated in the dicta of APCO that I referenced above, to seek to appropriate it for the benefit of ratepayers is, in the judge's words, highly sophisticated opportunism, and would in the end simply increase the utility's capital costs. So therefore, the problems with the Commission's decision on the SIF are multiple and in some cases compounded. Jurisdiction. SIF is not this Commission's purview, clearly that of the Financial Services Commission. So when it accepted this point in its letter of May 19th, it should have maintained that position. That decision is compounded by a decision which is outside the ambit of its supervisory and enabling legislation, ordering the setup of a regulatory liability account in the manner as ordered is plain and simple an asset grab based on a faulty assumption that ratepayers have an interest in the subject asset. To make the order is to indulge in retroactive rate making, which is unlawful and breaches fundamental legal principles. But then the decision compounds it because it also breaches the legitimate expectations of a proper corporate entity that wrote to the Commission, wrote to the FFC, wrote to the central bank, paid taxes to the government of Barbados, and now finds itself facing sanction by the very regulatory body that previously said, not my concern. Any reasoned review of the decision as it relates to the self-insurance fund requires substantial variation. As it relates to errors of law within the Commission's decision, the applicant argues that the Commission failed to discharge its statutory obligation to set fair and reasonable rates through its inconsistent application of the adjustments relative to the test year. Section 10 of the URA sets out the Commission's statutory duty to ensure that every rate is fair and reasonable. A critical aspect of determining fair and reasonable rates is to settle the test year that will be utilized in the determination of the rate, as the Commission rightfully indicates in paragraph 34 of its order and decision. The determination of whether a test year is appropriate for setting rates is whether it's representative after adjustments of the period which rates take effect. To this end, the Commission, in assessing adjustments to the test year, determined that energy usage in the test year was abnormal, and a normalizing adjustment to test year revenues was necessary. In seeking to effect the change, they ruled that the base revenue, customer count, usage, and demand values from the period ended June 30th, 2022 for the purposes of determining the overall revenue increase, tariff revenue requirement of each class should be used. The Commission itself positively quotes at paragraph 94 of the order that the adjustments to the test year ensure an accurate measure of costs incurred in conducting operations over a 12-month period, and to fix rates that will produce revenues to match the cost of that period. Further, at paragraph 95, the Commission identifies and indicates normalization adjustments are made to revenues or expenses to offset unusual operating events. Having decided to change the period over which BLPC was to adjust test year revenues, the Commission was obligated to ensure that it also looked at normalization of expenses to match the changes that were made. However, in paragraphs 117 to 126, which address test year expenses, the Commission only applies itself to actual expenses claimed by BLPC prior to filing the application. At no point were the expenses adjusted to ensure that the same coordinated with the adjusted revenue, and the inconsistent treatment of the adjustment produces an unfair result. In the Authority of Davenport Water Company versus Iowa State Commerce, the Supreme Court of Iowa quoted with approval the order of the Commission as follows: "It is fundamental to a proper test year that costs, both investment and operating, and revenues match. That is, that they be consistent with each other. Unless there's a matching of costs and revenues, the test year is not a proper one for fixing just and reasonable rates. The inclusion of costs without matching revenues will produce excessive rates. The inclusion of revenues without matching costs will deny the utility reasonable rates. The relationship between costs and revenues for the test period used and the validity of that relationship constitutes one of the most vital areas in the determination of just and reasonable rates. We are therefore of the view that the Commission has failed to discharge its duty to set fair and reasonable rates through an inconsistent application of the adjustments relative to test year. This aspect of the decision should be reviewed and varied." Continuing as to errors of fact, an area of significant concern is the failure of the Commission to properly consider the evidence concerning accumulated depreciation. I believe it's fair to say that there is no disagreement between the Commission and the applicant as it relates to the value and import of international accounting standards, and specifically as it relates to subject number 16, which calls for periodic review of residual value and useful life of assets. However, this is not reflected in the decision of the Commission. A direction that rates determined over 16 years ago, using factors that have changed significantly, runs counter to practical realities of the operations of this utility. Applying 2009 rates to assets brought into service 5 to 10 years later has consequences such as no rates for AMI meters or solar farm equipment, all improvements of which this Commission is aware. This creates false regulatory assets. The inequitable result is made worse when the fact of the applicant's increased investment in rate base over the years is factored in. This false premise is then compounded when the Commission holds at paragraph 91, as it relates to BLPC's depreciation differences that have emerged since 2013, the Commission finds that the final difference between the two accumulated depreciation amount should be recognized as a regulatory liability included in rate base and returned to ratepayers. And that's an important word there, returned to ratepayers. The period of the amortization of this liability is not mandated by any particular principle, but a 15-year amortization approximately aligns with the weighted average remaining life of BLPC plant. Therefore, the Commission determines that the regulatory liability shall be refunded. This finding presupposes that the applicant received an overcompensation or benefit because it followed IFRS rules and updated its residual value and the useful life of assets. This did not occur. Customers never paid 1 cent more than what was approved in 2009. And let me repeat that. Customers did not pay 1 cent more than what was approved in 2009. The only possible result, even if the commission was correct, was an understatement of returns on investment, and that is a book entry. So for the commission to order, in effect, a return to ratepayers of monies they never contributed exacerbates the effects of the faulty premise. The evidence is clear that returns on investment since 2010 were anemic for the applicant. So even if they were understated, the applicant never would have met the approved return or any position of an overcompensation. Following an arbitrary rule that approved rates must apply no matter how long ago approved, no matter if the applicant made multiple requests for updating the rates, and no matter if their application results in the absurdity of false regulatory liability, calls this ruling into question. To further order return of monies never contributed aggravates the injustice of this ruling, and aggravates an aggravation that is placed on top of an $88 million shortfall in regulatory expenses. The applicant also argues that the commission exceeded its jurisdiction and therefore acted ultra-virus in its ruling on treatment of deferred tax liability. As has already been highlighted, we explained the commission's error in relying on Capital Corp in the present circumstance. There was no unlawful act in this circumstance. There's no such allegation as relates to the issue of deferred tax liability. Therefore, there was no legal basis to engage in retroactive rate-making evidence within the decision as it relates to deferred tax liability. The Commission's treatment of tax benefit does not fall within the recognized exceptions, nor does it accord with principles of fairness. Northland Utilities and Northwest Public Utilities 2010 case is instructive. In this case, the issue put before the court was whether the board exceeded its jurisdiction when, as part of its rate-setting exercise for the period 2008 to 2010, it ordered the applicants to flow through to customers money received as a result of a tax refund for operations in 2007. There, it was stated, I agree with intervener's counsel when he argues that the 2007 tax refunds cannot be considered an efficiency gain. They came about due to a change in federal tax policy, as opposed to any efficiencies. But if it is a windfall, then the solution is not to provide one to the 2008-2010 customer base. The solution is to concentrate on developing appropriate rates for the test years based on current knowledge. Any attempt to deal with the refunds received for 2007 within the context of the 2008-2010 rate application is, in my opinion, tantamount to retroactive rate making. Calling it a prospective adjustment is merely doing indirectly what cannot be done directly. It is axiomatic that the courts will look to the substance of what is being done and not merely the form, and strike down any attempt to do indirectly what a tribunal's enabling statute does not allow to be done directly. And we argue that that is the present situation in this case. You can't seek to get around the legal impediments and jurisdictional limits by indirect methods and relying on semantics. The advice in the decision above was to utilize the knowledge gained from the fact of the previous rate adjustments and make appropriate rates based on the test year, not to seek to do indirectly what you're prohibited from doing directly. And I will say that that last sentence also applies to the reasoning in relation to the SIF that I mentioned earlier, whereby there's a limitation on the Commission's jurisdiction as it relates to the regulation of the SIF. But you say, I'm not touching the SIF, I am touching the funds that came out of the SIF because they're related to utility assets. It is basically seeking to do indirectly what you're not allowed to do directly by your enabling legislation. The Commission also failed to properly consider the evidence submitted relating to the 5 megawatt energy storage device. In its decision and order of April 13th, 2018, The Commission determined that the costs associated with the 5-megawatt energy storage device were reasonable. They stated, the Commission acknowledged that energy storage deployment will become a central focus for BLMP in transitioning existing grid infrastructure to better cater to issues of efficiency, energy dispatch, grid resilience, reliability, and management. The Commission recognizes the commitment of the applicant to the national clean energy vision. Given the myriad benefits to be derived from the inclusion of an ESD in the grid generation mix, it is anticipated that all stakeholders, customers, utility, and the environment stand to benefit from its utilization. Therefore, the Commission considers that the investment is justified. In its rate review application, BLPC sought the Commission's approval to include the undepreciated portion of the 5-megawatt ESD, capital investment and operating costs in rate base. This was $11.6 million as of December 31st. In addition to the evidence within the application, there was further evidence through interrogatories issued by the Barbados Renewable Energy Association. The Commission determined in its decision that BLPC has not demonstrated that ESD is economical over the life of the facility, nor does it provide ratepayers with an acceptable fuel cost reduction as compared to the capital investment. Prior to purchasing additional energy storage, the company will submit a full economic cost benefit analysis of the new energy storage, which demonstrates it provides an acceptable economic benefit. They further determined that BLPC's request to recover is denied. The applicant contends that the Commission's determination in relation to the 5-megawatt ESD is an error of fact. The applicant further contends that the Commission made an incorrect finding and believes that the matter should be reviewed and the decision varied. The Commission, in reaching its decision, focused solely on and gave predominant weight to the initial business case of the applicant's battery providing fuel savings and ignored the evidence from the applicant that demonstrated that the initial business case had evolved, and now more than 4 years hence, the battery provides more than just fuel savings, but is an integral part of the applicant's operations, in that it also provides frequency regulation, peak shaving, solar firming, and other ancillary benefits that stabilize the grid and enhance reliability for customers. The Commission, in effect, ignored its previous finding that I've read, expressed above. The Commission ignored the ambitious nature of the BNet for electricity production in Barbados to be 100% reliant by 2030, and the IRRP, which strongly supports and requires the installation of large increments of batteries. It can't be that the policy of the government of Barbados is to make this investment. It can't be that the Commission in 2013 said it was a sound investment, and when the applicant comes and asks to recover the costs associated with the investment, it is denied. There will be no inclination to an applicant to provide the further investment required to meet that 2030 BNet guideline and envision. And therefore, the reference earlier to what a good corporate client Light and Power would be would have to be called into question when our decision of this Commission means that it has to relook the manner in which it puts forward its investments. The decision, if left unvaried, will result in the applicant's inability to recover the full cost of an asset that customers are benefiting from, but failure to allow the applicant to recover the full cost would result in the taking of the applicant's property without the opportunity for just and fair recovery. Again, a violation of Section 3 of the URA. Additionally, the Commission's decision has far more wide-reaching effects in that it's misaligned with the BNet and the need for batteries to provide grid stability to the electric network. The issue of customer reliability is placed in jeopardy. This is not just a question of cost. The 5-megawatt ESD is used and useful, is in keeping with its obligations to provide a safe and reliable electricity service, and thus properly belongs in rate base. By not allowing the ESD to be recovered fully deprives the applicant of that to which it is lawfully entitled. The Commission violated the important regulatory principle of regulatory certainty and consistency. And this again relates back to the decision in relation to the self-insurance fund. And it can also be a complaint made as it relates to deferred taxes, as well as the 5 megawatt ESD. In ATCO Gas, and this is now a different decision, this is 2009 Alberta Utilities Commission, the principle of regulatory certainty recognizes there is significant benefit and strong preference for certainty and stability in the regulatory process. For public policy reasons, companies should have the ability to operate in an environment that is predictable. The Commission agrees with its predecessor that it is important for the public, including utilities, to be able to rely on the finality of its decisions, subject to any appeal remedies that may be available. The decision under review in this hearing is substantive. It's the result of review of thousands of pages and filings and days of testimony. The Commission took the time to lay out the respective arguments of the applicant and interveners and apply their analysis and ultimate findings. And I commend them. It was not an easy task. The issue, however, that calls the decision into question is a repeated failure to follow core regulatory principles that underpin acceptable and fair rate making. Rate making that protects the interests of the consumer while ensuring a reasonable return on capital for the service provider. We have already canvassed multiple breaches of these principles. The breach of the rule against retroactive rate making condemns the ruling as it relates to deferred taxes, condemns the ruling as it relates to the self-insurance fund. The breach of the rule of regulatory certainty condemns the ruling as it relates to self-insurance fund, deferred taxes, and the 5 megawatt ESD. When the applicant sought the Commission's directions on these matters, it should have been able to rely on the finality of the decisions that were given. Public policy dictates that companies should have the ability to operate in an environment that is predictable. The Commission has the opportunity in this review to affirm this principle by varying the decision to reflect and be consistent with its prior indications. Thank you, Chair.
Thank you. I now invite the Barbados Renewable Energy Association to make their presentation. You have 45 minutes in which to do so.
Good morning, it's Robert Goodrich from the Barbados Renewable Energy Association. We have submitted our participation today that it would be in an observer status only, so we will not be providing a submission today.
Okay. Thank you. Intervener team, Watson and Simpson.
Good morning, Mr. Chairman and members of the panel. Good morning to the members of the team for the applicant, to the interveners who are present, and to the Commission staff. Mr. Chairman, we have been very thorough in our written submissions. We note, with no little irony, that while the Barbados Light and Power characterized our written submissions as unremarkable, the same Barbados Light and Power strongly appealed to the FTC, to this panel, to strike out our written arguments, knowing full well that we'd then be obliged to waste a majority, if not all of our 45 minutes of oral submission, just trying to recover that ground. Thankfully, the Fair Trading Commission made the correct decision and accepted those written statements. It's also somewhat ironic that the applicant then spent another 24 pages quarreling about those submissions, but we're going to use our 45 minutes. And you can be rest assured that these 45 minutes and our written submissions would be extremely helpful to the Commission in making its determination. Panel members, I have addressed the issue of the threshold question at length in written submissions. I will merely reinforce those submissions with the Commission's statement in its 2019 decision on the Barbados Light and Power Limited's motion to review and vary the decision of the Fair Trading Commission on application of the BLMP to recover the cost of the 5-megawatt energy storage device through the fuel clause adjustment. I will call it the ESD decision as I go ahead. In that decision, the FTC stated, quote, "The Ontario Energy Board has previously determined in its natural gas electricity interface review decision, May 2022-2007, that in order for an applicant to meet the threshold question on filing a motion to review, it must demonstrate that the error which it alleges in the decision it wishes reviewed is identifiable, material, and relevant to the decision which was made. Such an applicant must show on a prima facie basis that there is enough substance to the issues raised in their motion for review, that a review based on those issues could lead to a variation or rescission of the original decision. It is insufficient for an applicant to demonstrate that it is dissatisfied with the decision, which is the subject of the motion, and the motion must not be used as an opportunity to simply re-argue the applicant's case. I must repeat, it must not be used as an opportunity to simply re-argue the applicant's case, which frankly is what the applicant has done throughout its motion for review, and it's done that here again today. I want to spend some time on this ESD decision, Mr. Chairman, members of the panel. The applicant's counsel and I agree on the importance of this decision. And the applicant has pointed out to the Commission that it should follow its own precedents. They referred to that again today, that decision. And we, this team, we strongly recommend the learning in that decision to the Commission itself. I compliment the Commission on the learning enunciated in the ESD decision. We must make clear first what is meant by prima facie. First, the Commission deals with that concept. Quoting Black's Law Dictionary, the Commission said, quote, "The establishment of a legally required rebuttable presumption, a party's production of enough evidence to allow the fact trier to infer the fact at issue and rule in the party's favor." I will add that prima facie evidence is evidence that is sufficient to establish a fact or raise a presumption unless disproved or rebutted. It is a Latin term. It means at first look or at first sight. This means that the Commission is not meant to go searching for the applicant's evidence in support of its grounds in the motion. The evidence must be sufficient and clear on the surface. On review of the ASD decision, panel, you will see that the Commission found time and time again that the BLPC, the applicant, then and now, had not proved the grounds stated in support of its request for a review in that case, but that in the public interest, it would vary one aspect of its then decision. A careful analysis of the applicant's motion, this current motion, and its arguments in support will show that the applicant has absolutely not met the threshold test. The applicant has merely used its motion to re-argue its case, to complain that it is dissatisfied with the Commission's interim compliance decision, and to complain about this team's and interveners' event submissions in particular. The applicant has not raised any issue of substance that could justify the Commission reversing or varying any element of its decision. The applicant also has not and cannot demonstrate how the reversal of the February 2023 decision would be in the public interest. They use those words, but their arguments saying that your decisions will be against the public interest are specious, and we will deal with this we have dealt with it in our written submissions, and we will deal with it also here. We're not going to repeat our written submissions. They're already on record. The applicant has failed to meet the threshold test. Now let's turn to the motion. On February 15th, 2023, after taking its time and using the 4 months after the rate case oral hearing ended to analyze the applicant's evidence, the applicant's written arguments, and the intervener's positions and arguments, the Fair Trading Commission issued an interim compliance decision in that rate case. It is important to take note of what I just said. The FTC didn't rush to issue a decision. And in its February 2023 decision, that decision is not a knee-jerk response to this application. it is your considered decision after conducting a thorough analysis of the record up to that point in the rate case. Indeed, when Barbados was clamoring for a decision, they thought it was taking too long. The FTC, in a media release dated 21 October 2022, quoting Dr. Marsha Atherley Akechi, CEO of the Commission, said, quote, "With the oral hearing completed, the Commission now awaits the closing statements from the interveners, which, as agreed, are to be submitted by Friday, October 28, 2022. And once this information has been submitted, the electricity panel, with the assistance of staff, will begin the process of reviewing all the arguments and evidence presented during the proceeding." Later in January 2023, the FTC CEO is reported in Barbados media as saying, quote, "The electricity hearing panel, with the assistance of FTC staff, is reviewing all of the arguments and evidence presented during the process, including over 1,300 pages of the application, over 1,000 pages of submissions, and over 1,900 pages of transcripts. On completion of the full assessment, the FTC will render its decision." The applicant likes to put forward a position about what is settled law, and by its tone and declarations, which may sound authoritative and correct, but which often is absolutely wrong. A position is not settled law that the Commission has to accept as gospel because the applicant said something or wrote something down. Some words and some numbers and designate it as settled law. The applicant very conveniently disregards the FTC's duties, which include monitoring the rates charged to ensure compliance. And what is a rate? What is the FTC tasked in law to monitor to ensure that the applicant is compliant? The FTC is mandated by Barbados law to monitor every rate, fare, toll, charge, rental, or other compensation of a service provider, to monitor rules, practices, measurements, classifications, or contracts of a service provider relating to a rate, and schedules or tariffs respecting a rate. This means, by way of example, an example that is very relevant to this review, that when the FTC rules or orders that the depreciation rate for a capital asset is X or Y, the Barbados Light and Power Management cannot sit in their offices and decide, "No, we don't like that order. Who cares what the FTC and the law say? We're going to change that so that we can collect more money from ratepayers without going back to the FTC." They simply cannot. And to allow them to, or to accept that wrongdoing, that illegality, would, without holding them accountable, would be to be complicit in the wrongdoing and in the illegality. Let me explore that decision briefly. That's your February decision. Before I do that, though, I invite all interested parties to take the time and read the entire decision carefully. 127 pages. It is a comprehensive document that was obviously carefully researched and considered. The effect of that decision is that the FTC dismissed, I'm going to say the practical effect, dismissed the Barbados Light and Power's application and rejected the requested rate increase as unproven and unjustified. That is effectively what the decision does. And the BLP, and what the BLP is questioning in this motion. As the Barbados newspapers declared, the FTC said no. We understand why the Barbados Light and Power is aggrieved, because the FTC's February decision resoundingly dismisses their request for the rates in this application. Of 16 schedules filed by the Barbados Light and Power as evidence to support its application for a rate increase, not the fluff, but the numbers, the real nitty-gritty of the application, the FTC has rejected 14 of them, thereby also rendering the verbal memoranda evidence derived from those schedules to be irrelevant. That is 88% of the BLPC supporting information and data rejected. It's not a small decision that they're asking you to vary. It is not a mere calculation. That's 88% that you found it fit, correctly so, to reject. By any measure, that is a failing of the application. In addition to saying that the BLPC that its evidence cannot be relied upon to set any rates, the FTC said a few key things, and I'll highlight some of them here. Quote, "The Commission is of the view that its decisions concerning the following: 1, the withdrawal from the SIF and payment of the same as dividends to shareholders, or 2, the excess accumulated deferred income taxes following the 2019 corporate income tax rate change, do not amount to impermissible retroactive rate making. Those positions do not reset rates previously established. Rather, the positions establish the initial treatment of unusual gains to BLPC, not expected or considered in the establishment of prior rates. About the self-insurance fund, the FTC ruled, quote, the money set aside in the SIF, in addition to being funded by consumer rates, ensure the continued provision of electric utility service in the event of a catastrophic event. And quote, the regulation of insurance entities is the purview of the Financial Services Commission. However, it is clearly within the FTC's jurisdiction to regulate the rate recoveries from monies that support insurance and the SIF, as well as the rate treatments of monies removed from the SIF for non-utility purposes. And quote, BLPC is provided with an opportunity to earn its authorized rate of return and has the ability to seek rate increases where existing rates are not sufficient. Quote, the Commission also notes, this is really important, also notes that its 2010 decision set rates based on estimated SIF contributions of approximately $7.6 million. However, BLPC's actual contributions to the fund were reduced to $1.6 million in 2011 to 2013 and have ceased since. About the accumulated depreciation, the Commission ruled that the BLPC has illegally ignored the FTC's orders and approved regulatory rules for calculating accumulated depreciation, and the BLMP must stop. The BLMP must recalculate according to the rules, according to the law, and the rate base must reflect the adjusted accumulated depreciation as ordered. I want to pause here because there's a specious argument made that they're not getting extra money. But those incorrect figures are in the rate base for this current application. So they would be seeking to get the additional money. And the FTC must not be misled on that point. That is a point to play to fool the public, but we know how it works. So though that incorrectly determined accumulated depreciation will affect ratepayers if the FTC reverses its decision. That the Commission has directed, the Commission also ruled that you have directed BLMP to apply to the Commission for and obtain approval for the regulatory treatment associated with changes to the company's depreciation rates. Now let me come in here again. It is clear from how this order is framed, and I read it time and time again, that the FTC is well aware that the BLMP thinks that just because it sent a letter or an application to the Commission, it can then go ahead and implement what it asked for without going through the lawful process and without any further reference to the FTC. And that the FTC, it is clear that the FTC opposes the company's moves to use whatever depreciation rates it feels like using in charging Barbados' customers. We are not surprised by BLMP's unlawful actions in this respect, and it's unlawful. They're going to come later and talk about umbrage, but it's unlawful because it goes against the lawful rulings of the Commission. We commend the FTC for telling the Barbados Light and Power that it will no longer allow them to thumb their noses at the laws governing rate regulation in Barbados. Interestingly, the Barbados Light and Power is doing that right now by failing to follow the law and serve its compliant filings on interveners, and by failing to file its mandatory confidentiality requests. We recommend to the FTC that it strongly reject such illegality. But I digress, and I'm going to move back on to this motion. What did the FTC say about accumulated deferred income taxes in its interim compliance decision? You said that the BLPC proposed and were granted rates in 2010 that assumed a certain tax rate and that allowed the BLPC to collect that expense, deferred, of course, from that deferred tax expense in rates from consumers. That tax rate was slashed by the government in 2019. That is not a secret. And BLPC therefore cannot enrich Emera at the expense of poor Barbadians by keeping that surplus money. But the FTC is magnanimous and has, wrongly in our view, I must admit, said only pay back 50% of that surplus. And you can take 15 years to pay it back. But there is no doubt that the FTC said it is wrong on the part of Barbados Light and Power. The FTC also said, and I quote, while the Commission has previously ruled on the rate treatment of certain income tax issues, the Commission has not directly ruled on the rate treatment for changes in the corporate income tax. Now that the issue is directly before the Commission, and with the benefit of the record in this application, the Commission is of the view that changes in income tax rates does give rise to rate-making consequences, and that excess added should be factored into rates. Similarly, deficient added should be factored into rates as appropriate. That's a balanced view, and no one can reasonably argue against that position. Now, what is the BLPC's answer to all of that, all of what I've cited before in this motion for review and variation? The Barbados Light and Power's answers are simple and straightforward, but so very, very dangerous in their brazenness. Let us consider those answers. So that the BLPC cannot take umbrage, I will use their words, settle in their motion and response to our written arguments. First, let's consider the self-insurance fund. Both the Commission and the applicant spent a lot of time and effort on the rulings related to the self-insurance fund, and I think it is appropriate for us to do the same. It has been controversial, it is important. With respect to the February 2023 findings and orders regarding the BLPC's improper handling of the self-insurance fund, the company accuses the FTC of, quote, having full awareness of the applicant's reduction of SIF funds almost 10 years earlier. About the FTC's order regarding the BLPC's improper withdrawal from the self-insurance fund, the applicant goes on to say, quote, the periodic regulatory filings it makes to the Commission reflected the diminution in funding of the SIF. At no time during that period did the Commission indicate that this was an issue for it or that it would investigate the matter. It may be considered at worst a dereliction of duty on the part of the Commission and at best a failure to pursue this matter on behalf of consumers. That for over 10 years after the action, the Commission made no move to set right what it has described as an improper withdrawal from the SIF, but takes the opportunity when the applicant makes a rate application to claw back funds which were never deposited in the SIF from consumer rates in the first place. So first we have the admission that they took the money and did not put it in. How ridiculous is that? But of course, the Barbados Light and Power very conveniently and dangerously doesn't say, well, it says the funds were never deposited in a kind of backward way, but that is some $81 million worth of money from tax, from consumers, 81 million that were collected, and the BLPC having specifically asked for those monies to deposit them into the fund, not to have as a slush fund to do other things with, not pay dividends or meet other expenses, but to deposit them into this specific vehicle that is specific. That the BLPC collected the requested 7.7, I say 7, rounding it up, million every single year since 2010, and is still collecting that money. Let us understand they're collecting it today still, and that since 2013, they have not put a single cent, not one, of that $7.7 million in the self-insurance fund, and certainly have not paid those monies back to ratepayers. And then they turn around and took $99.5 million, almost $100 million, out of the fund and paid it directly to Emera. That they did that is nothing short. For me as a consumer and as a regulatory expert, it is appalling, members of the panel. And the Trading Commission cannot permit that. Cannot permit that to continue. And you cannot approve of that action. What BLPC is here to suggest to you, to your face, to the government of Barbados, to consumers in Barbados, is that the FTC was derelict in their duty. That is their words, those are not mine. And because of that, the FTC can't come around them now telling them to correct the wrongdoing. The BLPC is here to say to the Commission that, excuse the colloquialism, this is how we talk, that the FTC, because it didn't pull them up in 2013 and stop them again in 2016, the FTC must now let BLPC keep consumers' hard-earned money, hard-earned, that it confiscated under the pretense that the money totaling $7.7 million annually would be deposited into the fund. They want you to accept that that is okay and that they can pay that money to their shareholder. The BLPC is here saying to you that the FTC has no power or authority to tell them to obey your orders. And by the way, too bad for the consumers, the government of Barbados, too bad for the people of Barbados if, God forbid, we have a catastrophic event. And having raided the self-insurance fund, because that is what they did, they beg Emera for help, and Emera does not accede to their request, because it doesn't have to. All of what I've just said is the crux of their argument against the FTC's ruling on the self-insurance fund. How totally ridiculous, how disrespectful of the Fair Trading Commission, how disrespectful of the law, how disrespectful of the people and the government of Barbados. The BLPC argues that in making its rulings on the self-insurance fund, the Fair Trading Commission is acting in excess of jurisdiction. Another specious argument. Under the Utilities Regulation Act, the Commission must monitor compliance with rates. The Commission is mandated under its empowering statutes to do all that is expedient and necessary to ensure compliance with the rates. And I told you what a rate is. It's not just the money that they collect. It is everything underlying that rate. And the applicable provisions are the basis of the Commission's jurisdiction. This is my assistance to you here. Those provisions are the basis of your jurisdiction over how the applicant has misused the funds in the SIF, and your jurisdiction over the applicant's refusal to deposit monies collected from consumers that it said is to go, or I should say, the monies that are to go into the fund, not into a bank account and, you know, sit around there and collect interest. It was designated for the fund. That is really important. Additionally, the Barbados Light and Power, by its own actions and indeed its own arguments, contradicts itself in its argument that the FTC has no jurisdiction in respect of the fund. First, in 2009, the BLPC itself included the request for rates to include monies, for deposit to the self-insurance fund in its own application. That is a recognition of your jurisdiction. Secondly, the Barbados Light and Power went to you seeking your approval to restructure the self-insurance fund and was persistent in going after the Commission for that go-ahead so that it could say to the other regulators, we have the FTC's permission. Therefore, the BLPC itself acknowledges your jurisdiction over the self-insurance fund, and it cannot now be permitted to petulantly deny that jurisdiction just because the FTC has refused to give a stamp of approval to their wrongdoing in respect to the fund, and it is wrongdoing. The argument that the FTC cannot affect the applicant's property interest, meaning the money collected in rates, this is the argument that they put before you today. However, the money, if improperly collected or improperly utilized, where it amounts to a confiscation of rates from consumers, then those monies are not their property. That is the law. Our written submissions address this issue thoroughly, as does the FTC in its decision. The Commission has not misdirected itself, as the applicant's counsel alleges. The Commission's reasoning is sound, it is fair, and it is in the public interest. The Commission is correct in its rulings and orders on the self-insurance fund, thankfully made in the best interest of consumers and generally in the interest of Barbados, considering our vulnerability to hurricanes and the unpredictability of potential catastrophes. The BLMP has not made any new arguments in its efforts not to be held accountable for its improper treatment of the self-insurance fund and its confiscation of rates from consumers on the pretense that the money would be deposited into the fund. Remember what the FTC observed in its decision. Based on the numbers, on the facts in this case, and it bears repeating even if I lose a few seconds, the Commission, quote, the Commission also notes that its 2010 decision set rates based on estimated SIF contributions of approximately 7.6 million. However, BLPC's actual contributions to the fund were reduced to 1.6 million in 2011 to 2013 and have ceased since. In paragraph 24 of its June 5th, 2023 further response, the applicant in a series of comments sought to present its failure to deposit into the SIF the appropriate rates collected in the name of self-insurance funding as, quote, prudent decisions in relation to the management of the utility and the SIF. The applicant in that further reply, I want you to follow me carefully here, repeated testimony given by its managing director, Mr. Roger Blackman, which stated, quote, it wouldn't have been prudent for us to maintain it at that level and continue contributing to something that just would have been a cost that we would have to come back and ask for recovery on. That's at paragraph 24.2. Further testimony from Mr. Blackman is reintroduced in an attempt to re-argue the applicant's position in defense of not depositing into the SIF the appropriate rates collected in the name of, on the promise of self-insurance funding. Quote, our sales revenue had been down by $34 million compared to what was included in the last rate decision. Quote, depreciation was higher by $53 million, in part because of the investments that we made over that period. Quote, the applicant made a decision to stop contributing to the overcapitalized SIF in order that the applicant could use those monies to help defray growing expenses in other areas of the business while operating in an environment with declining and flat sales. As a matter of uncontested fact, members of the panel, the applicant reduced its contribution down to 1.6 million from 7.6 million following in the next year immediately afterward, and discontinued payment altogether by the end of 2012. The applicant continued to charge those rates, even though it had stopped paying into the fund. We have the testimony of the managing director stating that the applicant, and it's the managing director, it's not some small fry in the company, stating that the applicant stopped paying those rates into the fund to help defray growing expenses in other areas. The data, however, show that at the time the applicant decided to stop contributing to the fund, around 2013, its operating expenses, less fuel, which is a pass-through and addressed by the FCA, stood at $141 million versus $144 million in the 2008 approved test year. And I'm taking this from information that they have supplied. Indeed, by the BLPC's and supplied in their response. Indeed, by the BLPC's own figures, its operating expenses, less fuel, declined consistently every year from 2010, when the rate was granted, through to 2013, when it decided to stop putting in the money. So it wasn't experiencing higher expenses, they were lower. The applicant's argument is not supported by its own evidence. On examination of the statement that, quote, our sales revenue has been down by $34 million compared to what was included in the last rate decision, that statement is also false. The data can be easily analyzed once the fuel revenues are removed. The data provided by the BLPC show that actual operating revenues, less fuel, were steady, averaging $200.2 million versus the 2008 test year value of $202 million, a variance of approximately 0.8%, I'm told statistically zero, versus the 17% that the applicant claimed. The data also show that in the 3 years following the 2010 rate decision, up until the applicant's decision to stop contributing to the fund, the operating revenues, less fuel, averaged $203.4 million, higher than the 2008 test year value of $202 million. On examination of the statement that the depreciation was higher by $53 million, in part because of the investments that we made over that period, that statement is false or at best misleading on multiple counts. The data show irrefutably that the approved depreciation, or more accurately, depreciation charge in the 2008 test year was $37.3 million. In the 10 years following that 2010 decision, the depreciation charge did increase. The 2019 charge was, as the data show, $46.2 million. However, the $9 million actual increase is not the claimed $53 million increase. Furthermore, the $9 million increase was not as a result of any significant investment made by the applicant. Recall that the applicant did not invest in the Clean Energy Bridge during that period as it had promised. A review of the annual changes in depreciation charges taken from the annual regulatory reports reveals that the greatest single year increase occurred between 2015 and 2016, some $7.9 million. Further inspection reveals that a large portion of that increase in depreciation can be attributed to the company's resurrecting the steam plant that it had previously fully depreciated and written off the books, plus its re-rating of the LSD spares from 16% to 33%. It should also be noted that the increase includes the depreciation in respect of the Trent Solar Farm, for which both the Commission and the applicant are aware the costs have already been agreed to be recovered via the fuel clause adjustment in accordance with the Commission's 2018 and 2019 decisions. A final point on the increase of depreciation expense. The Memorandum on Income Statement, Schedule D of the 2009 rate review application records the 2008 test year depreciation as $37,260,519. The BLPC's reported depreciation in 2013, the year in which it ceased contributing to the SIF, was in fact, $36,075,049.12, actually less than the 2008 test year approved allocation. Finally, just one more point on this, in its further reply to responsive interveners, the 5th June submission, the applicant provided a spreadsheet entitled Schedule A, 2009 to 2020 BLPC expenses comparison, and made reference to that schedule at paragraph 24.5 of its submission. It states the applicant has attached a copy of an expense comparison spreadsheet, etc., etc. When we open the attached spreadsheet, that is the Schedule A, and we are presented with, in its usual non-transparent style, which you yourself have noticed, the table purports to show the change against the 2008 test year, and that table very simply shows 5 rows of data. When we dig deeper, however, we can find 68 rows of hidden data. You have the tables, you can check it for yourselves. The Commission is reminded of its finding, stated at paragraph 68 of its February 15 decision, reflecting on the, quote, BLPC's lack of transparency in the application and interrogatory responses. This submission of this schedule is further proof, as if any was required, that the Commission's findings with regard to transparency of the applicant are well-founded, and that in spite of what the FTC has said about that lack of transparency, the applicant continues with its less than transparent ways. We have shown in our written submissions and in this submission here that I'm making that the BLPC has earned $81 million from Barbados' electricity ratepayers that it was supposed to contribute to this fund, that it didn't put into the fund. That is on top of taking out the $100 million. The FTC's wanton handling of the self-insurance fund brings to mind the proverbial hand in the cookie jar. The FTC has correctly said a resounding no to this. This intervener team concludes that the FTC, having taken its time, having examined the evidence and arguments of BLPC, none of which have changed, having considered the submissions, cross-examination by interveners, cannot now find or create any grounds at all for reversing or varying its findings and orders regarding the self-insurance fund. It is settled law that even if a commissioner or multiple commissioners were to have a change of heart, since the February decision, the applicant still has shown no valid legal grounds for reversing or varying any of the findings or orders. Consequently, we submit that those orders and findings must be confirmed by the Commission. They are solid, they are reasoned, and they are just. There's another argument of the Barbados Light and Power that is quite disturbing and that must be rejected outright by you, members of the panel. The BLPC is submitting to the FTC that because the FTC did not enforce compliance with its orders and rulings in the past, it cannot now require the BLPC to comply, and that it cannot order the BLPC to remedy the wrongdoings that you have discovered. Excuse me a moment. The BLPC argues that it has a legitimate expectation that the Commission would not, quote, rewrite history and use an unconnected rate-making exercise to recharacterize the withdrawal of $99.5 million from the SIF as a regulatory liability. But again, the BLPC's counsel misdirects the panel on the law. First, the SIF regulations mandate the purposes for which the SIF monies are to be used. That's settled in the schedule to the regulations, which the BLPC has constantly and conveniently ignored, but that is part of the law. Paying that money as a dividend to a shareholder is not one of those statutorily mandated purposes, notwithstanding that the provision says if you don't use the fund the way you're supposed to, you have to pay taxes. That's just to say, give it your taxes. But it doesn't say you get to lick out the fund. The FTC deals very thoroughly with this in its interim decision. By that I mean the February decision. But the SIF is not the point I'm focused on here. It's the container for the money. Had the insurance rainy day fund been kept, I don't know, under a mattress, the principles for retaining that fund would still apply. And the Barbados Light and Power could not simply reach into whatever the container is and withdraw the money and pay over to its shareholder as dividends. The FTC would, in such a case, still be responsible for monitoring that money, because the Barbados Light and Power said we're going to collect some money and we're going to put it over here for this purpose. That falls within your jurisdiction. But the BLPC goes even further into misleading the panel by suggesting that legitimate expectation can apply in respect of an illegality, because misusing those funds was an illegality, is an illegality. Besides the fact that the FTC never said, go ahead, take out the $100 million and pay it to Emera, the FTC could not have approved a breach of the SIF regulations. And the FTC could not approve the misuse or misapplication of the $80 million collected. In fact, the FTC is duty-bound under law to ensure that the company does not engage in such acts, that the company does not engage in confiscation of rates from consumers. The BLPC's expectation, therefore, is not legitimate. It is unlawful. In articulating the law in Commonwealth Caribbean administrative law, a treatise that the applicant has elsewhere and elsewise strongly recommended to the Commission, which we support, Professor Eddie Vento states at pages 199 to 200 the following, quote, "An important question which has challenged the scope of the doctrine of legitimate expectation is whether the court should give effect to a legitimate expectation that is unlawful. The Commonwealth Caribbean courts have made it abundantly clear that such expectations have no legitimacy and could not be held valid in the face of a statute making the action itself unlawful. In other words, the unlawfulness of a practice, promise, policy, or the like is sufficient for the courts to reject it as not being legitimate in law. And as mentioned above, good public administration favors the court to uphold the law even in the face of expectations created and reliance placed on such unlawful expectations. If the expectation is unlawful, it is no answer that the applicant has relied, even to his detriment, on that expectation. It seemed, therefore, that the unlawfulness of an expectation is a complete answer to the question of whether a public authority should be bound by such an expectation." He goes on to say, to allow the public authority to be protected by the defense of unlawful representation seems unfair. And this is in relation to their assertion that you said they could go ahead. To allow the public authority to be protected by the defense of unlawful representation seems unfair, but the court should be consistent in this regard. There should be no exceptions to this, even though this would lead to unfairness in particular cases. Council also throws in the concept of estoppel, but estoppel is not a concept to be thrown about loosely. Let us talk about estoppel as well. The Commission is required to consider the fact situation in the case cited by Council today, and we will note that Council doesn't actually tell you what the relevant authority in that case, what their authority's powers or duties were in that matter. That is relevant as to whether that case is applicable here. The applicant will be well advised, though, to consider that the principle of estoppel works against it, and I will explain this. Rate hearings are a forum by which the Commission, as an administrative body, considers pleadings both in support of and in opposition to applications for rate increases. And utilities companies provide services to customers on the basis of a contract, the compact that we hear about, those terms that bind the respective utility and the customer. They provide service, we pay for it. That there exists a legal relationship between utility companies and customers of those companies is clearly discernible. In the context of an application for a rate review, the FTC stands in the gap between the utility, which in this instance is the monopolistic Barbados Light and Power, and the electricity consumer. The FTC, therefore, in addition to its statutory responsibility, is charged with a duty analogous to that of a trustee acting on behalf of the beneficiaries who it represents as that trustee, be the consumers of Barbados Light and Power. The relevance of equity and equitable devices is therefore applicable here. Cordellini and Cordellini, quoting Justice Denning, in Central London Property Trust Limited against High Trees House Limited, assert that, quote, a promise intended to be binding intended to be acted upon and in fact acted on is binding insofar excuse me, as its terms properly apply. And the English Court of Appeal has also said, quoting Lord Justice Gibson, quote, a promissory estoppel, in my judgment, arises where there is a clear and unequivocal promise that strict legal rights will not be insisted on. The promisee has acted in reliance on the promise, and it will be inequitable for the promiser to go back on his promise. Now, what was the promise? The promise is we will collect this money, we will provide a service, and we will put money in the self-insurance fund. And so the BLPC's undertakings or promises relating to the self-insurance fund and other promises, including the promise to replace its then aging generation plant and to finance this initiative using the rate increase granted in 2012, was a clearly articulated pillar on which the FTC made its decision. This decision of the FTC's and the consequential payment of increased electricity rates created a contingent obligation on the part of the Barbados Light and Power to maintain the self-insurance fund, to deposit the $7.6 million into it every year, not to undermine the insurance coverage of transmission and distribution and generation plant and equipment and buildings, and that is what they have done. That statement of intent to deposit the fund the money into the fund in order to ensure that we as a country will have energy security and will be able to recover from any catastrophic damage. Under the circumstances, those are effectively promises on which basis they benefited to the detriment of Barbadian consumers who paid a higher price for the Barbados Light and Power's product. In short, Commissioners, the Barbados Light and Power is wrong on the law and on the facts. You are correct in your decision. You have not exceeded your jurisdiction. You have not engaged in administrative wrongdoing. And you must unequivocally reject this argument from the Barbados Light and Power. I'm told I'm about to run out of time, so I'm going to move on to another issue. And that issue is in relation to your denial, the Commission's denial of the additional insurance expenses that the Barbados Light and Power has sought. They have spent considerable time on that issue. And I've reread and reread the Commission's statement. The correctness of the finding is obvious to me, panel. The Commission quite obviously means that the self-insurance fund is an insurance fund. Therefore, the Barbados Light and Power should not be incurring premiums where the statutory fund has been put in place to cover certain risks. In that respect, the Barbados Light and Power has persisted in misleading the Commission regarding cover for generation plant. And the law is clear. Generation plant, buildings, and contents are to be covered by the fund. And BLPC has refused time and time again to definitively answer in a straightforward manner questions put by you and by us about whether the self-insurance fund was being utilized to insure generation plants. So they can't now come back, not having provided the evidence we have asked for, to say, give us insurance money, but we will not tell you that it will be used in one way or another. And so I agree with the Commission's findings for the purpose of this review that your finding should stand unless the applicant can show some error of law or similar infraction committed by the Commission in arriving at your decision in relation to the fund and in relation to the denial of the increased insurance expenses. Now, another dangerous argument of the Commission, this is the final thing I will address, the Barbados Light and Power. It has said more than once in this rate case that the information supplied by it to justify a rate increase is a mere projection. That we can agree, and we can agree it's true that it's a projection. We can also agree that business conditions can be fluid and that the management acting prudently must make decisions about the conduct of business. However, that argument does not apply in respect of the decisions made by the Commission in its February 2023 decision for reasons that we have explored. The BLPC cannot be permitted to submit information to the FTC about projected expenses or capital expenditure, get acceptance of that cost information for rate-making purposes, get an approved rate increase, on that basis, charge and collect the rates, and then turn around, not invest or spend the money, pay the money confiscated from ratepayers to its shareholder, and then sell the FTC too bad. You can't rely on the information that we present in a rate case, and you can't expect us to follow through on what we swear, because it's sworn evidence, we will spend that money on. Council likes to use the term capricious. It's a good word. And the actions of the company in respect of monies collected for the SIF, money collected for installation of the 22 megawatt MSD, money collected for future expenses is capricious. The FTC is correct in stating, quote, however, the use of money set aside for future expenditures of the utility and paid by customer rates is not a fair and reasonable method to satisfy shareholder returns. BLPC always had the right to seek a rate increase if it does not meet its desired return. Such a rate proceeding would be before stakeholders and the Commission and afford due process to all interested parties to achieve a rate that is fair and reasonable. The Commission cannot buy into the arguments of BLPC that I just described. Should the Commission buy into that argument and reverse or vary its very correct rulings on the basis of such arguments, it will be giving the BLPC and all other utilities carte blanche to lie to it in future applications for rates and to do as they please in disdain of compliance requirements. It will be relinquishing your investigatory and monitoring powers. It will be relinquishing your rate setting powers. It will be reducing the Commission to a mere rubber stamp, to a mere extension of a utility, in this case, the Barbados Light and Power. It would be an astonishing act of self-destruction for the Commission to commit against itself. The Commission is urged to be mindful of the message that its treatment of such arguments will send not only to the Barbados Light and Power and its parent company, but to the other public utilities that it regulates, and now to the hundreds of electricity service providers that you regulate. Chair, the Barbados Light and Power, in referring to use of the IFRS as a basis for determining accumulated depreciation, says that you should not seek to...
Yeah. Your time is up, so if you can just...
Yes, I will wrap up.
1 minute.
Thank you, Chair. Much obliged. Chair, I will end by saying that, because we've addressed a lot of these issues, I want to say in relation to the test year that in our view, and we've said from the beginning that 2020 is inappropriate. It is not reflective of a typical operating year. It is an aberration historically. And we have no argument with the submission of the company that if you're making changes to sales and revenues, you will make changes to expenses. What we are saying, however, is that we are now into 2023. The financial statements for audited for 2022 must have been prepared by the Barbados Light and Power because they have to be filed with Barbados authorities, and its parent company has issued its own consolidated financials, including financial information related to the company, and it has paid a dividend. So, and of course, they must have submitted the regulatory reports to you by now. So the Barbados Light and Power should be required to utilize the full completed 2022 as a test year. That is our recommendation. We think that the FTC is correct to reject 2020, and we support the FTC's submission in relation to the test year. The Light and Power has not given any good reason why your decision should be overturned. Mr. Chairman, I thank you very much for the time and the extension, albeit a minute, and for the Commission's attention, and I will now cede my platform to the next intervener. Thank you.
Okay, thank you. Okay, we'll take a 15-minute break before Mr. Wendt makes his presentation. As we continue our hearing, I now invite Mr. Kenneth, intervener Mr. Kenneth Wayne, to make his presentation.
Thank you, Mr. Chairman. FTC management and staff, the board, the commission, the managing director, Blyton Paul, the management and staff of the FTC, fellow interveners, the media, persons in the room who are attending the hearing, others online, ladies and gentlemen, greetings to everyone. Our team of Dr. Ali Alfar, Mr. Adlai Stevenson, and Tony Gibbs, and I welcome this opportunity to present our perspective on the BLPC's motion to review. We have already submitted a 101-page report to the FTC on the motion to review in early May, and last week, on the 24th of August, 2023, we filed a letter which showed that the adjustment of the $1.54 million in depreciation expense of the company is necessary. We'll discuss that a little bit further. In the time available today, we would still like to cover the energy storage device. We'd like to look at depreciation and the accumulated depreciation, the self-insurance fund, the corporation tax gain, the capital structure, and the test year. And Mr. Chairman, we will try and abridge that because you already have a lot of the arguments, but we need to explain those carefully, especially the highlights. It is likely that some person will be online listening, so we want to allow us to put some context. So in presenting our submission, we would have reviewed the 1,300 applications that was filed on the 30th of September, a depreciation decision of the FTC of the 25th of March, pending ruling, the public hearing, the interim decision that came out that presented BLPC with a 50% rise on the 1st of November, and that was given on the 16th of September 2022. We had a 15-day public hearing with transcripts of 1,868 pages, and that concluded on the 14th of October. In the interim ruling, 127 pages that the BLPC required BLPC to make a series of adjustments, and that was issued on the 15th of February. The BLPC's motion of 62 pages, which the company filed on the 7th of March, and the interveners' responses, and the motion to review that mostly filed in May of 2023, and much more. Now, apparently, from our understanding, the grounds for motion based on the utility regulation rules include error of law or jurisdiction, error of fact, a change in circumstances, new facts that have arisen, and facts that were not previously placed in the proceeding and could not have been discovered at the time, and an important matter of principle that has been raised by the order or decision. Now, while we tended some layman sort of moral arguments in relation to the motion to review, our submission today, presentations is mostly based on pointing out errors of facts, new facts, and facts that have not yet been previously raised. There are few instances where our findings may vary from the position taken by the FTC, but in general, the facts uncovered unequivocally support the Commission's ruling. So let's start then by looking at the energy storage device. Now, based on a review of the application, the FTC decision on the 15th of February, and the applicant's motion for review, there seems to be no dispute that the cost of the assets acquired by the BLPC has generally been recovered via the rate base, but as above in 2018, the BLPC proposed that the cost of the SD be recovered through the fuel charge adjustment instead of the rate base. That's the 2018 decision, page 3, 2023, decision paragraph 49. The BLPC provided formulas for the cost recovery via the fuel charge adjustment, and that was back in 2018. That's in the decision. The references are there in my submission, Mr. Chairman, so allow me not to have to include them there. But I might call on one or two of them, but they're there. So, and the FTC accepts that. So the fuel charge adjustment as the appropriate recovery mechanism, claiming that the ESD's ability to deliver fuel savings and benefits will deliver the ratepayers from the price or operational risk associated with traditional costs. Ratepayers will be protected from the technology and operational risk associated with the ESD, which is borne by the shareholders. On the rate-based methodology, the customer would be financially disadvantaged while the fuel charge adjustment provides efficient cost recovery. The use of the fuel charge adjustment would also mitigate the need for rate reviews, which are costly and resource-intensive. The fuel charge, the ultimate cost of such changes are borne by the customers, and that would be avoided. And to ensure that only prudent incurred costs are recovered, this is more easily achieved on the fuel charge adjustment. And those are all decisions of 2018, which were good arguments that were made in support of the fuel charge adjustment. The projected fuel savings exceed the total cost of ownership, as the BLPC will absorb the unrecovered costs. This was the position back then, the 2018 decision, page 6. The recovery of capital is based solely on the ability to achieve the projected savings. And BLPC proposed that the Commission has the flexibility to allow the recovery of the ASD costs via the fuel charge adjustment. And the Commission has the power to make those adjustments to any form that was provided. The FTC approved the BLPP's proposal that the cost of the ASD be recovered via the FCA in 2018. Cost recovery using the fuel charge adjustment approach was approved for a period of 3 years and then subject to review for, I think, within 6 months. The review of this writing based on our information available does not seem to suggest it's taken place, but that's something that I'm sure would be done. The FTC views now on what the applicants projects was that the BLPC stated that it shared information on the FTC and the application response to interrogatories, interveners, which presumably was meant to include change in the cost of recovery of the mechanism from the fuel charge adjustment. So they probably meant to do that. However, the FTC stated that the BLPC's application does not provide any evidence of the need to change the current cost recovery method. And that was in the 23 decision on page 21. The BLPC indicated that the calculation of the rate basis shown in their Schedule C1 in its application includes the unrecovered cost of the ASD. However, by ruling of the fuel charge, the customer remain to be maintained through the fuel charge adjustment. It means then that the FTC does not support that portion of the ASD being recovered in the rate base. The BLPC contended that the FTC focused solely on losses and gave predominant weight to the initial business case, providing fuel savings, and ignored the evidence of the outcomes of that business. The FTC was of the view that the BLPC has not demonstrated that the current ESD is economical over its life, and they have no information that could be identified to suggest that they focus solely. We couldn't see any information that they focus solely on losses. Against the above background, then, the motion, the review in relation to the ESD or written submission do not see any means of supporting a view that the FTC only focus on losses. The BLPC asserted that the Commission failed to properly consider the evidence submitted, and in our view, the vast majority of the arguments supported the view that the battery storage will play an integral role in the transition in fossil fuel, so the arguments are well documented. In relation to the capital recovery, though, BLPC presented great arguments in 2018 to support the recovery through the fuel charge adjustments. And even when four of the six interveners at that time, differed, our team could not identify any evidence that the applicants in the document referred to suggest that the overall benefits of the fuel charge adjustment approach no longer applies. We discussed the Commission's position on losses, and we have seen then, in our view, that the Commission, in determining the fuel charge adjustment, did not only focus on loss. Indeed, Mr. John Griffith, the Commissioner John Griffith, engaged with the applicant's witnesses through a hand seal, and that's transcripts 11, paragraphs 34 and 3404 to 3520. And our team supports the Commission's view that they gave attention to losses, but that was not the only thing. With regards then to the change in the cost of recovery then approach, the BLPC contended that the Commission's determination to 5 megawatt was an error in fact. In making this claim, BLPC said it believes that the issue was not sufficiently canvassed during the rate review hearing. With that admission, the question must be asked in relation to the matter of cost recovery, whether there was opportunity for BLPC to do so. So one, they could have presented simple, clear reasoning in an affidavit, that there's a need in the change from the fuel charge adjustment, or specify why a change was warranted in responses to interrogatories, or they could have outlined any shortcomings in its responses during the hearing. Based on all our findings, we could not find any information that the BLPC provided that kind of information, so we shared the board's view on that. Our team, therefore, was shocked to read that the FTC ignored evidence from the applicant that the initial business case has evolved and that it wasn't taken into account. With regards to the matter of cost recovery, again, there are a number of precluding that BLPC facts in support of other requests of cost recovery that will no longer be recovered via the fuel charge adjustment, and instead the net book value should be recovered in the rate base. Now, it is well established that the burden of proof is on the utility, so accordingly, our team submits that the BLP should not have to await the commission or the intervener or any other party to inquire about it. The transcripts of the intervener, Teresa Watson, with John Hargraves, that's paragraph 596 to 624, and that will be on day 11. The transcripts of the 11 between intervener Colonel Brown with, again, Joanne Graves, that's paragraph 2455 to 2477, and the transcripts of the then public counsel Sharon Dean on the 20th, on the 11 again, that will be paragraph 2866 to paragraph 91. So as you can see from above, all the exchanges, the subject of battery was raised on several occasions during the public hearing, and our team could not locate any information from the transcripts which outline reasons as to why the cost of the recovery mechanism for the ESD is necessary. Consequently, we do not support the view that the FTC's determination in relation to the applicant's 5 megawatt is an error in fact. Now let's look now a little bit closer at the ESD and compare the fuel charge adjustment versus the rate base. Now at page 21 and paragraph 52 to 54 of its 23 decision, the FTC noted that A, BLPC seeks the Commission's view, and I'm quoting, in the application to include the undepreciated portion of the 5 megawatt ESD capital investment and the operating costs in the rate base. According to BLPC's witness, Mr. Ricardo Jennings, the undepreciated ESD cost is $16.448 million at paragraph 52. Mr. Jennings testified that the amount of revenue recovery over the first 3 years of the ESD operation was $2.7 million, 95% of the fuel cost saving, and when that's adjusted to take into account that 5% goes to the ratepayers, the savings equate to $2.84 million, and that's paragraph 53. Assuming that the same rate of recovery over the 10-year life of the ESD total, the ESD life cycle savings would only be $9.47 million. Thus, fuel savings over the life of the ESD would only will only cover about 41% of the ESD capital cost. And that's the quote coming from the decision which the Commission would have taken from Jennings. Now, the above computation would have been correct if the undepreciated ESD cost, the net book value at December 31st, 2020 was actually $16.448 million. However, the undepreciated ESD cost was actually $11.6 million as of December 31st, 2021, and that is now in the BLPC's motion for review at paragraph 82. Indeed, reference to the Barbados Light Power Company Limited fixed asset summary, that historic cost 2022 C2 utility and service on page 69 of the application, volume 3, you will see that the historical cost of battery in the ESD at December 31st, 2018 was $16,447,572, which approximate to the $16.448 million. And that the written down value on depreciated cost of the SD at December 31st was $11,610,051. That's the 11.6 million. So our team believes that any pronouncement by Mr. Jennings that the undepreciated ESD cost was $16.48 million may have been a genuine error, as he would have been on the stand for a prolonged period, similar to our experience earlier in giving witnesses on this evidence on the stand for several days. We don't think that was an attempt to mislead the board. The fact is that the undepreciated portion, although stated by Mr. Jennings, is 16.448 million. In that quote that I read previously, the undepreciated portion is 11.6 million. So let's compare then to see, out of the two methods, which would then recover the investment to address this matter of fact. So using the correct undepreciated cost of 11.6 million at December 31st, our team computed the capital recovery proxy for the SD using the fuel charge adjustment mechanism as follows. Since the ASD was approved on the 1st of September 2018, then a portion of its cost would have been recovered over 2.525 years, and that's between the 1st of September 2018 and the 31st of December 2020. As per above, the historical cost of the SD was 16.48 million. Hence, the investment of the ASD recovered, it would have been, since it was installed, would be 4.8 million. In other words, that would be 16.448 million minus the 11.6 million, which is 4.8 million, because the original cost was 16.48, and we have seen that the unrecovered force is 11.6 million. Almost 30% of that 16.4 million investment would have been recovered in just 2.25 years. So on that trend, the BLPC would fully recover its costs on the fuel charge adjustment mechanism in 8.5 years. Now, on the other hand, if that cost was via the established rate-based method, then the SD would have been depreciated over its life of, I think, if you're using 10 years. The annual depreciation expense on a straight line basis would have been 1.645 million. That's the 16.448 million divided by 10. So the total accumulated depreciation in 2.25 years would have been $3.7 million. So the net book value would have been 12.748 million, which is the 16.48 minus the 3.7, instead of the 11.6 million at 31st. So a comparison of the cost of the via the FCA approach with the rate-based mechanism shows that BLPC would have enjoyed a more generous cost recovery using the former, which is the fuel charge adjustment, than the latter, the rate-based. Specifically, the applicant would fully recover its cost to acquire the ESD within a shorter period of 8.5 years under the fuel charge as opposed to 10 years under the rate base. So consequently, based on the above, the data our team disagrees that the BLPC would not be allowed to fully recover its costs. The ESD. So in summary, on the ESD, we cannot see any reason at all to support the removal, the change that the board has recommended that the fuel charge adjustment should be continued. What we would say, and we will come to that, that in the letter that we presented last, I think it would have been last Thursday on the 24th, we pointed out and showed that the fuel charge, the electronic storage device must be removed from the rate base, as well as the associated depreciation of $1.564 million. So you would see that information there. So if you have time, you can go through it, but at this time, I'd like to leave the SD.
Yes.
Just a question, a quick query as to the Commission's treatment. Intervenor Wendt is referring to a letter he sent you last week with a stated position in terms of action. I am not understanding that the letter is either before you for the purposes of this hearing or to be considered in the context of any determination you make. Is that correct?
Yeah, we didn't do that.
Mr. Chairman, it's 11:37. Just letting you know that I expect interruptions.
Yes, the letter is outside of the filing deadline, so it's not part of the record.
Thank you, Chair.
Mr. Chairman, with the greatest respect, the letter used information that was from having read the Fair Trade Commission document, which is the decision, and I've explained it so I couldn't get it in before. The figures are showing that you have presented a scenario in the decision which includes $1.548 million for the ESD. this is an opportunity review to show that that 1.58 million that is included in depreciation should not be part of that schedule. So it's an error of fact. And based on my understanding, this motion for review is to look at errors of fact. And all I've done, no new information.
Mr. Vent, we're saying you can make your submissions here, but do not refer to the letter.
Sorry, sir. Right, allow me to continue. Because
okay, so you make your presentation now, but do not refer to the letter.
I'm going to have to look at that, because that is 1.548 million, but that's in the decision.
No,
and I'll come back to that.
Mr. Vent, you're speaking about the information now that can form part of the record, not the letter.
Okay, I'm with you, sir. So all I have to do is make sure that you are clear of the points, the facts that I'm pointing out.
Yes, sir.
I appreciate it. Now, in relation to depreciation, this is a nice point to touch on depreciation. Mr. Chairman, I'm going to have to move quickly given the time, but I expect more interruptions. Now, the board would have given its depreciation decision on the 25th of March 2022, and that is after a series of changes and submissions by the applicant and so on. We would have liked to go through those, but we're not going to have the time. But what we're going to say is that the FTC disallowed the depreciation rates for the generating plant. And that was in that decision. It pointed out that it no longer used its proposed depreciation rates that it included in the application. Instead, it was stressed that the existing depreciation rates for generators had to be applied. Now, when we looked at the information from the applicants and the filing now, we have seen that depreciation in each year from 2018, depreciation depreciation rates were 1 to 10%, which gives depreciation expense of 21.3 million in 2018. 2019, 21% to 10%, and these are coming from the annual reports of the non-consolidated report, 20.52 million. And in 2020, the test year, these depreciation rates are now increasing from 1% to 10% to 2 to 33% for generation, which now has caused the depreciation expense to jump from 20 million to 27.5 million in the test year. Now that is critical. Hence, so for rate-making purpose, what we are seeing is a significant jump of $7 million. And that would have been one of the reasons for that is because, why? Now, the Light and Power says that it would have had a study done by, I want to get the correct name, sorry. Right. Yeah, there was a study done which in 2012 that indicated that the IFRS rates were utilized, yes. In accordance with the FTC part to prescribe lives, the depreciation rates followed its review and analysis of depreciation filed by the utility. Once the FTC prescribed rates, then those rates should be followed, as my colleague, Intervenor Watson Simpson would have said. Specifically, separate regulatory finances should be prepared where depreciation expense and the accumulated depreciation net values by the account should be set out in line with the FTC orders. It appeared that this process was strictly followed by the applicant until 2012, where the asset category, depreciation rates, historical costs, depreciation expense, accumulated depreciation, and so on, were all presented in clear schedules, and that's reference to the BLPC's 2013 non-consolidated finances, so that the BLPC then changed its policy in 2013. And it says, the commission, the company's policy is to undergo a depreciation study conducted every 5 to 7 years, and during the year, an American Appraisal Associated Inc. conducted a study. The rates in the non-consolidated financial statements reflects revised rates based on the completed depreciation study. The depreciation rates for generation assets are 1% to 7%. That was back in December 2012. And theirs which transmission was then, those rates were then changed from 1% to 5% to 1% to 7%. On transmission distribution, in 2012, the rates were 6%. After that study, those rates were changed 2% to 5%. And for the other assets, 2% to 17%, and this was on December 2012, they were 2%, so there was no change there. The impact of the rate change on the non-consolidated statements, comprehensive income for the year ended 31st, 2013 was at $2 million, and that resulted in an increase beyond what the board would have approved. It's expected that that impact will be consistent in future periods. So what had happened? The board had set rates for depreciation, and the company, based on the study by this American, and we have no disregard for them, the American associate that study, and they've changed the rates in 2012, which resulted, for the most part, from all the information that we're seeing, resulted in the difference between the accumulated depreciation by the company compared to what the FTC has actually determined. Now, instead of continuing to keep very clear relative accounts, BLPC began reporting accumulated depreciation and regular financial statements to the Commission by including an adjustment to reflect the difference between depreciation compared to, for the financial purposes, on the IFRS and regulatory financial reporting. And that would have been in the decision of 2023, page 29, paragraph 85. So while BLPC still presented the schedules to the FTC, it was not clear whether these rates used were approved by the FTC or the BLPC based on IFRS, as the schedule only showed the column with depreciation rates. That's one of the reasons Orton requested that the BLPC present the schedule showing us what? The FTC prescribed rates, and we have given you those in the schedule versus what the IFRS rates would have been. So we have outlined those and we've shared those with you. You can see that those rates for the depreciation rates, and if you only look at generation, were 1 to 5%, then they changed to 1.7%, then they later went to 10%. By the time the hearing get here in 2020, they're 2% to 33%. And these are all numbers that we have keyed from the PDFs that we were provided from the company. So on review of the information then, it is clear then that from the most recent approved rates that should have been used should have been the depreciation rates that the company set in 2009. Further, it's worth to reiterate that most of the recent depreciations only become effective the date on which this order is issued. Therefore, for the avoidance of doubt, FTC approved the rates that are unchanged between 2009 and 2022 until they issue the order and should have been applied throughout. Now, what we have done now is to look then after that at what do the depreciation rates overall show. Now, we have taken these depreciation rates exactly from the company's audited non-consolidated financial accounts from 2009 to 2021. And we have seen depreciation that was moving steadily from 38.1 million, 38.7, that's the total depreciation, to 39.7 all the way up. 1 year it dropped to 35, could have been retirements. But then suddenly now, in the test year, this depreciation expense is 52 million. That is the revenue, impact the revenue requirement. So we cannot understand that, Mr. Chairman. These dramatic increases, as we said, will be due to, when Dr. Alfar, our colleague, inquired about the depreciation computation, the applicant's expert, Peter Huck, he explained that the dramatic increase in the depreciation expense in the test year was mostly due to, one, the plant additions to the steam plant units 1 and 2, and they are the same old inefficient units that whose imprudent spend ought not to be allowed in the rate-making process. And 2, he also stated that the inclusion of the undepreciated balance of the 11.6 million, as we just spoke about, which the applicant requested to include in rate base, that was also one of the reasons why depreciation jumped substantially. More fundamentally, the prescribed rates, therefore, of depreciation from a critical component of the revenue, so that's why our team repeatedly requests over 10 different times that we want to have the breakdown of the depreciation rates. Now, we'll touch just quickly before we move on to some other matters. given the unnecessary convolution to approve regular rates in the FRS is why then BLPC must submit the board. It has correctly requested the revised revenue requirements to be utilized in determination of the final base rates, which shall utilize a rate base that includes the updated valuation of the plant and service, accumulated depreciation, accumulated deferred income taxes, and so on. And that's what the board requested then in its decision at paragraph 46 of the February decision. The applicant's claim as well include the rates does not reflect the depreciation expense or recovery investment. And there was argument today that the rates are 16 years old and therefore shouldn't apply to modern technology. The only thing that we have seen as you, Mr. Chairman, would have been the renewable plants as well as the same ESD, and if they have more, they can share with us. But most of the depreciation rates apply to the same low-speed diesel engine, apply to the same gas turbines, and applied also to the steam plant. So those depreciation rates, we have shown you in our schedules that those depreciation rates are even better than what the company is proposing. What has really changed is the fact that they've implemented remaining life from 2012, and the board only now approved the remaining life. And all this information is presented to you, Mr. Chairman. So I would like to have been able to go through it further, but I'm conscious of time, and I know I'm going to get some further interruptions. Now, the applicant's claim of the use of a regular asset of a liability will not enable BLPC to recover prudent costs incurred. Once the regulatory and IFRS rates differ, regulatory liability or assets will result, as correctly pointed out by the Fair Trade Commission. BLPC used different depreciation rates from those prescribed, which seem to be generally higher than the prescribed rates, apart from TD. Again, the FTC has the authority to prescribe those rates. However, BLPC seems to have the view that using IFRS rates as a basis to determine accumulated will result in a true and fair value of the accumulated depreciation, cost of service to customers, and cost of plant. And that's taken from their motion at page 78. So, as for the FTC order, as it relates to BLPC's depreciation difference that have emerged since 2010, the Commission finds that the final difference between the two accumulated depreciation amounts should recognize as a regulatory liability, including the rate base, and return to rate payers. It appears that the BLPC does not disagree with the fact that the accumulated depreciation balance based on regulatory discount rates will differ. The difference is that whereas the board would arrive at 469.9 million, the company will arrive at 557 million, and instead of accepting then the authority mandated depreciation rates, they have actually continued to use their own rates. Even in the discourse, which seems to appear, intervener Ms. Watson's asked in the hearing, asked Mr. Jennings, there's a variance between your financial statements based on the IFRS, and I'm quoting, and the regulatory reports, which reflects the approved depreciation rate. Is that higher depreciation in your, let's say, normal financial statements reflected of the company's concerns about recovery of depreciation costs? No. The higher, that's Mr. Jennings, no. Higher accumulated depreciation in the IFRS financial statement is on account of the adjustments to the retirement dates during the period 2012 to 2017. What's filed in the annual regulatory reports, in my view, that's Mr. Jennings' view, is not accurate because it does not reflect the remaining life and it does not reflect the actual depreciation that would have been incurred. I've stated in my paragraph 12 in my memorandum rate base that the 2012 and updated study was done and submitted to communities when applied to the approval that was then approved for in 2017. In the IFRS statements are updated with the correct reflection of depreciation, and that is reason for the difference. That was the response to intervener Watson, which clearly shows that the BLPC is aware that it did use the IFRS rates, that it implemented the remaining life procedure well in advance of the approval and authority given by the Commission. So we will have no more to say on that. So our team would still like to obtain the requested Excel format the information to determine the reserve imbalance, because once the rates are different, there will be a reserve imbalance. Even prior to receipt of that information, our team shares the FCC's view that the difference for the accumulated depreciation used for financial reporting purposes and rate-making purposes can re-emerge if BLPC undertakes further depreciation studies for financial reporting purposes. It is more striking that in the 2020 test year, the depreciation range for generation plants with BLPCs will see the upward limit in that range jumping from 10% in 2019, just 2019, to 23% in 2023, and even higher to 50% in 2020. Our team awaits information, but we support the Fair Trading Commission on depreciation. Mr. Chairman, a lot of discussion went this morning on the self-insurance fund. My fellow intervener, the Watson team, covered a lot of what I would have gone through. But I cannot leave here without touching on a few issues. So we endorse a lot of what was said this morning, but here's where we are. Prior to the 1999.5 million being withdrawn from the SIF in 2016, reference to the annual report, the earlier report, and that was report, and you could check that in the annual reports, we're under a heading Hurricane and Catastrophe Risk. That said, a study conducted in 2011 indicated that the amount held in the fund of approximately $128.4 million was adequate to cover reasonable risks. Based on the study, management decided to maintain contributions to the fund at $1.6 million. We already heard that that should have been 7.6, but they have decided on that. You could check the Light and Power reports on that. All these references are in my submission, so please allow me to proceed without doing that. So after 2012, only a further $1.6 million was added to the FIS, as the FCC pointed out, instead that BLPC continued to contribute monies to the SIF through 2013. Therefore, since 2011, a total of $3.2 million contributions 2012 and 2013 were made to the SIF. Remember, the study was done in 2011. So apart from the funds injected in the BLPC, it is known that the SIF also generates investments. So between 2012 and 2015, the total investment amounted to $10.46 million. Therefore, without considering any of the expenses, the added to the SIF would have been $13.66 million, which would be the $3.6 million that was the 1.6 for 2 years, plus the 10.46, which is in the that would have been from the investments. Now, consequently, it is more surprising that just 5 years later, when the study found that the $128.4 million in the SIF was adequate to cover reasonable risk, to provide for coverage in the event of a hurricane or catastrophe, that the fund value was being now reduced due to overcapitalization for an assessment in 2016. And in this regard, the fund was suddenly found to be overcapitalized by what? Nearly $100 million, when only $13.6 million was put inside the fund after the $128.4 million was considered adequate. So at the time that the $99.5 million was withdrawn from the SIF and returned to the company in 2016, only to be paid as a dividend in the said year, there was no concern on the part of the applicant that the FCC action or its own action would do what, in its words, reduce the approved rate base and return on equity below acceptable levels compared to BLPC's ability to maintain its plant and equipment. So once you take out the $99.5 million, there's no problem with it being able to maintain it. But once the board decides that it's going to say that that has to be refunded over a long period, then there's an issue. So in terms of redress, the FTC has not requested the company to return the $99.5 million in 1 year. Instead, the shareholders are being given 30 years to replenish the SIF. Not only is the ruling of the FTC overly generous, but also the action is equivalent to granting the stakeholder an interest-free loan of $99.5 million, which will a repayment of 30 years. Such a deal is hardly available for many countries. And for example, the Barbados government recently signed a US $150 million concerning loan with the Chinese government, and that was for road works, where it carries an interest rate of 2% and is repayable over 20 years. So now the only factor that, saves some grace is the fact that the MTC mandate that in the event of a catastrophe, bear in mind that although we give you 95 years, that the safe balance is directed to first deploy the monies in the safe balance, that regulatory liability. In light of the foregoing, our team does not support the view that the return of the 99.5 million of the BLPs directed by the FTC will contribute to an undue reduction in the applicant's approval for rate base and return equity below acceptable level and compromise the applicant's ability to maintain its plant and equipment and make improvements to provide service to the public. Our position is reinforced by the fact that, again, that having taken it out in 2016, there was no such concern. No. The BLPC of the view that contributes to the assist of shareholders' funds and not monies from the ratepayers. Let's look at that closely. Our team does not support the applicant's view that the contributions remitted is safe for shareholders' funds. Had the commercial insurance been available on similar or better terms, the funds would have simply been used to pay premiums, as was done for all assets. That cost would simply be borne by the ratepayers as a legitimate expense involved in the provision of safe and reliable service. So on the contrary, our team contends that the funds in the SIF forms part of the revenue requirement in 2009 application rate review, and that was expounded by my colleague. And it shows that if you go in that, and you reference and go into 2009, and we also will quote you 2010, you'll see that the total insurance was 12,919,000, of which 7.66 million related, expressly stated as related to SIF. Similarly, in 2010, the insurance was 12.64 million, of which 7.657 million was pertaining to the SIF. We have then provided you, Mr. Chairman, with a table that shows you every single year. We wouldn't go through it here. It shows you how much of the funds that the starting principal, the starting balance, the interest that was earned, the ending balance, and it shows you the amount that was injected into the SIF. Now, so investment income would have been earned, as we said before. So how are we going to look at this? That $7.6 million now, therefore, $6 million, has to be seen as an annuity. So if the company is claiming then that the money was theirs, BLPC would have collected $7.6 million from customers annually from the 1st of October 2009 until this date. If the interest of 5.25% on the debt approved in 2010 decision applied in computing the value, then this annuity then would have arrived at $160.78 million. So, Mr. Chairman, in our view, the $99.5 million cannot simply be given back because interest would have applied, just as you have said, to the company. If it is our rates for the interim rates are too high, then you will return the amounts to the ratepayers with interest. Similarly, we are saying that 99.5 million then, and that's if the money is theirs. I am not disputing. If this is theirs, then you repay $160.9 million. Now, if it is determined that the funds injected in the SIF was not theirs, then they should not have taken that money. So the 99.5 million should be computed similar to the annuity above, and since the fund would have earned income if these were not withdrawn, then the interest rate would be higher than the 5.25%. In this regard, the company's approved rate of return was 12.75 in 2010, although BLPC proposed a 12.5% in its current review. Our analysis shows that that return should only be 9%, return on equity. So consistent with our 9%, then we look at future value, net present value computation for that 99.5 million, then we have shown you that money that should actually be returned is 174.219 million without interest, and not the 95 million. BLPC advised that it openly notify the Commission, the FS, the Fair Trading Commission, the Finance Service Commission, and the Central Bank of its intention to withdraw the SIF and distribute the proceeds after $50 million in tax to the government to its shareholder in 2016. That's according to BLPC's motion. The company may contend that it paid the taxes of $15 million to the government. So if we exclude that, to be nice, from the $99.5 million, it would mean that would be $84.5 million, Mr. Chairman. So again, using the interest rate of 9% for return on equity, we show that even then, the return to the shareholder, to the ratepayers, should be for $141.715 million instead of the $99.5 million. So the FTC, so like the FTC then, our team feels strongly that is, to quote the FTC, that is a fair and reasonable outcome that the funds withdrawn in 2016 be considered retained by the Light and Power Company for the benefit of the utility operations or returned to customers. Any conclusion, this avoids in any conclusion that there's a perceived outcome that the use of the funds devoted to the future electricity utility services and funded by the customers' rates are being used for the benefit of the shareholders. Is in line, that is in line with forward thinking. Mr. Chairman, I would like to share a little bit more on this, but I think I've given you enough. The only thing that I'll take note of is that just bear in mind that if those funds weren't removed, then what would have happened is that there would have been investment income. And in that regard, it was observed that investment income in 2016 was $8.14 million, or 23% higher than most of the income earned in the year ever since 2009. This means that considerable income would have been foregone after the $99.5 million was removed. Since that time, it is also alarmed that professional fees incurred by the SIF, which were generally less than $55,000 between 2009 and 2015. These skyrocketed to nearly $500,000 in 2021, $492,000 to be exact. So when the investment income appears to be flat, if not declining at best, after the withdrawal of the $99.5 million, now the funds required to service this fund is suddenly up from $55,000 to $500,000. And finally, the accumulated net income that realized $36.78 million between 2009 and 2015 now shows a cumulative loss of $50.25 million in the 2021 accounts. So in essence, if review or otherwise that the contribution is safe are regarded as shareholders' funds, then the reimbursement would be $160.78 million to the consumers. On the other hand, if the contributions are considered to be injections made to the consumer, which our team contends, then the reimbursement will be $141.71 million, and that is just to take into account the tax impact being generous. Therefore, the FTC's decision to require the applicant to set aside a regulatory liability is justifiable, irrespective of whether the shareholders' funds or the ratepayers are determined to be the contributions to the SIF. In any event, the 99% was withdrawn in 1 year and paid its dividends in 2016. It did not reduce the rate base or the return on equity below accepted levels as the company contends. The only thing we would argue, Mr. Chairman, where we would differ with the board, is that instead of giving the company 30 years to refund money that they took out in 1 year, you would like to review that. I'd be generous to give them 5, but I will leave that with you. Let's turn now.
Mr. Vance, but your time has expired.
Mr. Chairman, you have all of my submissions. I want to touch on, and what hurts is that 2 of our interveners here are not here, which is 90 minutes. And I really don't want to...
No, that's not how it works. It's 45 minutes for the team.
Sir, we're representing the public. If you could give me a few more minutes, I'd be glad. If you said no, then...
3 minutes.
3 minutes. So, Mr. Chairman, in those 3 minutes, and thank you very much, I would have covered the depreciation, I would have covered the electronic storage device, and I would have covered the self-insurance fund. So very quickly, let me take a look then at this tax of the deferred tax. How is it that it appears the same thing happened in Tampa? Tampa Electricity is a subsidiary of Emera. And the same exact thing happened where the federal government reduced the corporation tax, and they themselves were able to get reductions for their ratepayers. What different to ours? So, Mr. Chairman, I would only say that we have computed some costs, and we urge the board that you should amortize it over 5 years as a max, and that was supported by intervening Mr. Ralph Smith, who you know could not be part of the proceeding, and I think your approach, I support his view instead of 5 years. If I turn now quickly to the capital structure, Mr. Chairman, the board pointed out that the Light & Ponds return equity in 2010 was 80% equity and 20% debt. The Light & Ponds says, I think it was a Kima study that they used that showed that across the region, that study showed that it was something like 50, to use to justify. They've asked the board when it was 80-20, they used a regional study that showed that the equity should be closer to 35, 65%, and that was used in 2010. Now, when we come to this right here, the current debt-to-equity ratio is 36% to 39%, or 71% to 74%, and that depends on when the CB is there. Mr. Chairman, you're familiar with it. So what happened? The board has said we are going now to use a 45%, 35%, 45%, 55% equity. And they said, but we're basing that based on the fact that when Dr. Volgenstein was on the cross-section, she says in Jamaica it is 50-50. Also, it was pointed out that the regional study, at that time, the regional study, again, was closer to the same figures that the board proposed. We cannot see on the same principle that the Light & Ponds had used in 2010, had they used that same principle, the difference between their actual equity in the books and what they proposed was about 15%. And if you do the numbers right now, what you are proposing, Mr. Chairman, and the Commission is pretty much the same thing. So you have no basis for changing that. I would only urge again that the change be over 5 years. And finally, Mr. Chairman, on the test year, I couldn't go through it as would like, but here are the tests here. We support the Commission's view, and we have already captured in the decision that if the company is arguing that revenues remain flat, it must be an adjustment within the test year where revenues dropped by nearly $10 million because of COVID and the shutdowns. Well, it cannot be now that in this right here, they want you to be able to treat 2023, and they made no adjustment in the application, which was most dishonest. There must have been a known unmeasurable change that COVID wouldn't be here all the time. So we were asking for the 2022 annual reports to get a look and see what it is. We asked for that a million times since January. I have not seen it. So in concluding, Mr. Chairman, your position that there's an adjustment in revenue required in the test year of 2020 is solid. And I would support the applicants in saying that when the Commission review it, if it is that they have shown that there's an expense that should be adjusted, please do that as well. But don't let nobody tell you that you cannot review any documents that were done in the past. Mr. Chairman, in closing, I'd like to thank the Commission, who has been kind enough to reallocate the time when I had the class action suit and schedule this hearing that I can attend. Mr. Chairman, the Commission should stay firm no matter who comes and in its position because they're solid. And finally, Mr. Chair, I'd like to thank all of the interveners. I'd like to thank all the media and everyone who would have supported us. And on behalf of that, Mr. Chairman, I wish the board every success because this is not a simple matter, but you've done a good job. Thank you very much.
Thank you, Intervenor Wendt. I now invite the Barbados Sustainable Energy Cooperative Society Limited, represented here by Lieutenant Colonel Brown, to make a presentation.
Okay, good afternoon, Mr. Chairman, and to everyone actually present. I really have no plans to use all of my 40 minutes. We have made our submission in writing, and we are quite comfortable that that covers the majority of our concerns. In addition to which, we want to place on the record our 99.5% support for the positions taken by, certainly by interveners Watson and Simpson and by intervener Wendt this morning. So we will attempt not to repeat that support. I will touch on our 0.5% deviation from them, being our contention that generally speaking, sir, the remedies prescribed in the decision of February do not, in our considered opinion, go far enough to address the clear violations which the evidence itself ascribes to the applicant, and in a number of clear specific areas, two of which are, obviously, the illegal defunding of the self-insurance fund by nearly $100 million, and over $100 million if you consider the additional implications of that removal of funds, and the deliberate refusal of the applicant to install new generating plant as provided for in the 2010 rate decisions by the Commission. Let me go, sir, to the whole question of the jurisdiction of the Commission with respect to the self-insurance fund, because the counsel for the applicant made large of that particular issue. That self-insurance fund, sir, is a critical, innovative, and fundamental component of the electricity infrastructure of Barbados. It not only provides critical sustainability insurance in the event that we were to suffer a major catastrophe due to a hurricane or some unfortunate hazard, but creatively, it has been designed to provide routine general insurance protection for the transmission and distribution plant, as well, sir, as the company's generating plant. Protection that would result in significant savings annually in insurance expenses if properly applied. These expenses, I remind you, sir, are borne by customers. In addition to this, Section 22 of the Utilities Regulation Act makes it elusively clear that no major changes to the operations of any service provider shall be made without first obtaining, and I want to emphasize this, sir, the written permission of the Commission. Not that you write the Commission or that the Commission write you, but it requires the written permission of the Commission before you can make these changes. Specifically, so the Act says, no service, this section 32, no service provider shall cease its operations or any part of its operations with respect to the provision of regulated utility service without first obtaining the permission of the Commission in writing. So therefore, the applicant's suggestion that the Commission, quote unquote, acted in excess of its jurisdiction with respect to the self-insurance fund has to be misguided. Indeed, I would suggest to you, sir, that the withdrawal of those funds without the written prior permission of the Commission makes the transaction contrary to the Act, and in our layman's term in the cooperative, sir, that's called illegal, and points to the fund's trustees as a party acting outside of the jurisdiction rather than the Commission. We would contend that unless the Commission takes satisfactory steps to correct this illegal removal of funds, the Commission itself may be in danger of becoming an accessory after the fact with this breach. Even more specific with respect to this particular issue, sir, than Section 22 of the Utilities Regulation Act, the Insurance Barbados Light and Power Company Limited Self-Insurance Fund Regulations 1998 that established that self-insurance fund. At Section 8, sir, stipulates that the fund, and I quote, the fund shall only be utilized by the company for the purpose of replacing or reinstating the self-insured assets which are damaged by catastrophe and reinstating the financial loss following such damage, end of quote. End of what the law actually says, sir. So I can tell you from our position in the cooperative, how such funds could be used to pay dividends to a sole shareholder defies all of our rational comprehension. I just want to make reference to this continued reference by counsel for the applicant about the fact that they paid 15 million or whatever million in taxes totally irrelevant, sir. What the Act says in 8B is that if for some reason, whatever reason, the funds are misused, not used for the reasons stipulated in the Act, well then instead of being tax-free, you have to pay taxes on it. That's obvious. Sir, there's a law that says you mustn't drive at more than 30 miles per hour. But if you do, you get a ticket. The fact that you're willing to take a ticket don't allow you to drive at more than 30 miles per hour. So I don't understand the point that the council is trying to make. Also, it is clear that the notification of the FTC, the central bank, the FSC, sir, even if they notify the CIA, is not relevant to the facts because the law is absolutely specific on how that funds. So the question of the jurisdiction of the commission with regard to this item is beyond any kind of rational question, and it bothers us that we continue to be hearing about that. Let me make it clear, sir, that the cooperative coalition is not here in this process to play any legal or highly technical games, although we can. Our sole role is to seek to understand, in layman's terms, how this whole matter of setting electricity rates and the administration and the regulation of the sector and how decisions are taken that affect costs to our ordinary citizens in Barbados, people out there who pay the bills every month. We are trying to understand how this works. I have to tell you, sir, that so far, it is very clear to us that the current process is not working. It is outdated. It is inefficient. It is embarrassing, sir, that 2 years ago, the electric utility could apply for a simple review of rates, something that, in our estimation, should be happening annually or at least every 2 years, certainly not more than 5 years, as stipulated in the Act. But how it could take 2 years and almost 2 years to the date from their application, we are no closer to giving them a rate. If, in fact, their financial situation was anywhere as dire as they laid it out to be when they applied, there would be no electricity in Barbados today, sir. They would be bankrupt. It cannot take 2 years to make a simple decision like that. That bothers us significantly, sir. Another issue that I wanted to touch briefly on, again because counsel for the applicant made much of it this morning, is this whole question, sir, of terms. Let me see if I can find it. Kept making reference to the whole question of investors, and investors putting their money where decisions can be, quote unquote, reversed after 6 years, in reference to the power of the commission to review things that happen and to make coherent decisions about them. Sir, according to our understanding of the definition of the term, investors are persons who fund the investments of an organization. The people who pay the money for the assets, for the operations, who pay the bills, sir. As we have said before, the people who pay the cost of the Barbados Light and Power Company Limited are the customers of the Barbados Light and Power Company Limited. Specifically, and we have outlined these facts before, between 2009, the last rate hearing, and 2021, this new application, the customers of Barbados paid $6.3 billion to Barbados Light and Power for the cost of electricity, including fuel and for all their operations. During that period, the persons that he seemed to be referring to as quote-unquote investors, namely the shareholders, a different set of people, made zero investments in the company. None. I dare anyone to define the word investor with relation to Light and Power to be anybody other than the customers of Light and Power with any kind of sanity, sir. And he went on and on about it this morning. That needs to be corrected in the record, and I call on the company to actually apologize for that error. He is actually referring to shareholders. Those shareholders own $200 million in shares. Fine. We have some questions about that too, sir, because prior to 2013, those shares were held by a variety of stakeholders, including customers, the national insurance company, ordinary Barbadians, companies in Barbados, companies overseas, a variety of different people. For some interesting reason that we have yet been unable to decipher, something happened in 2013 where one entity was allowed to own 100% of those shares and to take complete control of an organization where the assets actually belong to the customers. We're still trying to understand that, sir, especially in light of the fact that the FTC did not allow Sol to do a similar thing when they wanted to take over BNTCL. And more recently, you did not allow BICO to sell their shares to a Trinidadian interest because you were concerned about the impact on the market. And yet, in 2013, we found a situation where what was already a monopoly in terms of electricity sales was allowed to become a monopoly in terms of equity investment in that operation. A worrying situation from our perspective, and we are going to talk some more about that. So, Mr. Chairman, we find it difficult to believe that counsel for the applicant was serious in his lengthy contribution today. What we have here, sir, is a franchise holder whose license expires in 2028, and that is a fact for the record, attempting to argue seriously that the regulator has no authority to review decisions taken by that franchise holder to questionably extract huge amounts of funds, and sir, I'm talking about hundreds of millions of dollars, from the Barbados Light and Power Company Limited, to distribute these funds to shareholders. I'm talking about a single shareholder who is now making those decisions on his own. In a situation where their license expires in 2028. Now I have two questions.
Yeah. Lieutenant Colonel Brown, the purpose of the review is to deal with the threshold question and the grounds raised for the review and variation in the motion. So I would like you to focus on those things as opposed to some of the material which was already dealt with in the original hearing.
No problem, Mr. Chairman. Feel free to interrupt me because I don't plan to use the first for 20 minutes or whatever. But the point I'm making, sir, is the whole question of the jurisdiction of the commission to do what they're calling retroactive rate setting. And the reason why it is important that the commission has this power, sir, is because we are dealing with a franchise holder who may well not be here after 2028. So the question we have, sir, is if the franchise is not renewed by the government, who takes responsibility for that $100 million in funds that have gone on? It cannot be a 30-year arrangement, sir, when there's no guarantee that we have after 2028. Therefore, the commission not only has a responsibility, sir, but a duty to look at these exact what they're referring to as retroactive rate making. So there's not retroactive rate making. The last time they were before the Public of Barbados applying for a rate was 2010. Now they've come again in 2021. The commission has not only the right, sir, by law, but a responsibility to the people of Barbados, to my members, sir, to actually look at these things in great detail and to make sure that when 2028 comes, that asset called BLPC company remains a viable Barbadian asset, which it will not if hundreds of millions of dollars are questionably withdrawn. So there can be no question so you don't have to interrupt me again, sir. There can be no question of the right of the commission to review all of these actions that they bring into question and to do it in great detail, sir, and to take decisions that protect the asset that belongs to Barbados and Barbadians. BLPC cannot, sir, decide that they have changed the rules because it suits Emira, their shareholder. They cannot just ignore the FTC's regulatory prescriptions when it is inconvenient for them or for Emira. More importantly, sir, the FTC cannot allow this to happen. And this is not from the FTC's perspective. This is from Barbados' perspective. It's from my members' perspective. It is from the government's perspective. In fact, I have to tell you, sir, that from the cooperative coalition's perspective, we continue to wonder why the FTC has not yet invoked the offenses and penalties section of the URA, specifically sections 31 and 32, to be exact. BLP's stance on this motion is disappointing to us, sir. That's the honest truth. And we are hopeful that there will be a major review of their position, that there will be no change in the Commission's position, except to look at that long-term, soft-handed resolution of 30 years to redress a clearly illegal situation that happened in 2016 that should be resolved in 2016 and the corrected situation brought forward, as will be the case in any such financial illegal regularity. Thank you very much, sir. I don't need any more time.
Okay. Thank you, Lieutenant Colonel Brown. To the Barbados Business Development Division, Public Counsel, you're ready to make your presentation?
Thank you, Mr. Chairman, members of the panel. I am minded by your direction earlier that we are not here to rehash the case which was given at the hearing. But, sir, I come from a place which is called the Courts of Barbados, and I have only started this a week ago. I've been on a very serious learning curve. But something, sir, that I must point out is that the question of threshold is the most important question for the Commission today. The reason, sir, is that this is a situation where they are asking you, the applicants are asking you, having made a decision, to reconsider your decision, sir, on various points. Sir, I am minded as well, from the history of this matter, to recognize that they made the application. It was incumbent on them to produce all the evidence that they had, all the grounds that they were going to rely on, and that it was incumbent on them as well during the hearing, sir, to produce all the evidence, their witnesses and such like, to convince you. That transaction has been completed. You have made a decision, sir. And there is a principle, sir, that informs every adjudicating body, that there's a presumption of finality, so that public confidence would be engendered by persons who place their confidence in adjudicating bodies, that when they have rendered a decision, that decision should really stand. There's a presumption of that, sir. And to remove that presumption, sir, here, you have rules set out in 54.1 of the Utilities Regulations and Procedural Rules, which sets out the criteria for you to disturb that decision. So the question is whether the matter should be reviewed and whether there's reason to believe that the order should be rescinded. That's the most important question, as I have said. I have sat here, sir, and listened as the applicant sought to give reasons why you should disturb your decision. And the question remains still after they have given that, as to what error of law or jurisdiction have they put forward, sir? What error of fact have they put forward? What change in circumstances? What new facts have arisen? Or, sir, what important matter of principle has been raised by your order of decision, sir? They are claiming that unless you reverse your decision or points of your decision, that they will suffer irreparable financial harm, which cannot be remedied by damages. Sir, I am of the view that they have not proven their case to move you past that threshold. They have to prove their case, sir, on the balance of probabilities, and here they have to convince you that they have a justifiable reason or a justifiable point, sir, that is an issue. They have not done that. That is my humble submission. Sir, as I said, during the course of the hearing, they had a duty on the balance of probabilities to establish their case. They have not done so. You have made a ruling. During the course of the case, sir, they had an opportunity of cross-examining the interveners, answering interrogatories, and placing the case squarely before the commission. It is indeed a serious matter, and I believe that they should have approached it with in a serious way. They were ably represented, sir, by counsel, tremendous counsel. They had the opportunity, sir, of producing documents. They had the opportunity of arguing their case. They have argued something called they have examined, sir, something called the self-insurance fund. From my understanding, sir, the self-insurance fund, and I have to go into that a little bit, not, sir, to re-argue the case, but because they have raised it. And my understanding, sir, that it was a vehicle specially created under the Insurance Act, which allowed the Barbados Light and Power Company to create its own insurance fund, and for a specific reason, a particular object of protecting itself against catastrophe, building some type of resilience, sir. And it said, sir, this enabling vehicle, the act, which allowed them to do so, said that the fund should be utilized by the company for a purpose of reinstating self-insured assets if they were damaged by catastrophe. And it said, sir, further, that it should be utilized, if it should be utilized for other purposes, they would have to pay a tax. We understand that, and every intervener here, sir, has referred to that. It also allowed them, sir, that if they use it for any other reason, that they would have to pay the tax. Sir, when we apply the mischief rule, we recognize that the intent and purpose, sir, of that fund, it was almost as a trust, sir, a trust with specific objects, and that the real intention was to build resilience. And, sir, they have used some letter, which I think I have it on the record, and it's on the record too, in my bundle, and it's on the record, where they have asked the Fair Trading Commission about dealing with this fund. And the Fair Trading Commission said, well, we can't tell you how to deal with the fund. They have used that, sir, to buttress their case today and at the hearing maybe, to say that you had recognized that you had no authority to deal with the fund. But, sir, that is not a discrepancy I'm saying, because when you said that you did not have the authority to tell them how to deal with the fund, sir, it is not a discrepancy. But you have the authority, sir, that once a rate hearing is commenced, you have that authority, sir, to look at all the assets, the prudence and the management of the company, because they were saying that if they were not able during the rate hearing, sir, to secure a rate, a proper rate, they could find themselves in financial ruin. Anybody, sir, anybody, even if in domestic situations where somebody is saying that they are going to be in financial ruin unless, and they have a fund or ought to have a fund, the reasonable question would be, what have you done with that fund? What have you done with that money, sir? How are you now saying that you will find yourself in financial ruin if certain things are not done? Sir, the fact that they had this fund, sir, and that they disposed of this fund comes under your purview. You have the purview, sir, to investigate this fund, and you rightly did so. Sir, at Section 10B, 7 of the URA, Cap 282, it states that every rate made by the Commission shall be fair and reasonable. And, sir, and that you can take into account such matters as the Commission may consider appropriate. Sir, you exercise your discretion. That is a wide power that you had, and you exercise it properly. Sir, we contend that the determination of the hearings on the funds of the SIFs represented an asset of the company, and as a result could be taken into account by the Commission. The evidence given by the applicant during the hearing that the fund comprised of proceeds from ratepayers, coupled with the fact that it was set up for a specific purpose in mind, sir, as I said earlier, is analogous to the creation of what we call a constructive trust. The evidence showed that the company had disbursed a dividend utilizing the money from the fund to its parent company prior to the application of the rate hearing. Sir, this brought it into the realm of being a live issue, and one, as I said earlier, that you did take it into consideration, and that was rightly so. The issue of breach of trust, sir, will not necessarily be for this Commission, but the behavior has to be analyzed as whether it was financially prudent and what position it put the company in relation to its service to the ratepayers. All this evidence was revealed and supported by answers to various interrogatories, expert witnesses, and it was quite squarely before the Commission in this matter. The applicant's letter is not contradictory. It does not create any discrepancy or inconsistency in the evidence. It is our view, sir, that you were quite correct, and that the letter that they held out that is showing some contradictory position does not rise to that level. While we agree that assets may not become the property of consumers or ratepayers because just that they're paying rates, the Commission is still enabled to look at the usage, acquisition, and disposal of assets. For example, sir, if you were to buy generators that are inefficient, or you sell your inefficient generators and rely on inefficient one, that is a matter that the Commission can look at. The prudence, sir, of the operation. The applicant has argued as well that irrational decisions should be subject to review. Sir, there is no irrationality in your decision. The Commission was entitled, like a court or an adjudicating body, to draw inferences from the facts you find, sir. And nobody can challenge that once you apply judicial principles. And you have. Facts, sir, are important things, but facts are adduced based on the representations, based on how the persons give their evidence, based on the demeanor of witnesses. And a court, sir, should not, or this Commission, should not disturb its decision based on what they say is a misinterpretation of facts, just broadly put like that. That's what they have done. They are suggesting that you have misapplied your discretion or exercised your discretion wrongfully. But they have not shown that, sir. They have not shown that. And courts are very reluctant to disturb decisions based on an application of fact, an argument. Sir, they have spoken about reasonable and legitimate expectation. The applicant contends in his application that they had a reasonable and legitimate expectation, and that they relied on that reasonable and legitimate expectation in relation to the SIF, sir. Sir, the SIF, as I said, was analogous to a trust. A trust, sir, has certain equitable principles attached to it, sir. It is established, sir, for a particular purpose with certain objects in mind, sir. And, sir, anybody who understands equity would know that when it comes to equity and trust, sir, there are certain maxims that operate, sir, and you were entitled to infer this, and I presume that you infer this, that he who comes to equity must come with clean hands. He who asks for equity must do equity, sir. The question then is, can be put a different way. The ratepayers who had contributed to that fund, sir, had a legitimate expectation as well. They had a legitimate expectation, sir, that if a hurricane, God forbid, had ravished the island, sir, that the utility company on which they have been placing their money would have that type of resilience to get back up and running. That is the legitimate expectation that I am asking, and I'm sure that you considered, sir. That is this type of legitimate expectation. So legitimate expectation can be seen here as a double-edged sword, sir. Because, and he who does equity, but because, sir, don't let me get ahead of myself, sir. Because the consumers had a legitimate expectation that this money would be used for a specific purpose. That is the purpose of the vehicle. That is the purpose of the insurance act that created the fund. Ask yourself, sir, what did they do with the money? Was it equitable? Was it fair? Was it just to the consumers? And therein lies the answer, sir. And you made an inference, sir. You made an inference based on the evidence and the facts, which was within your discretion and which was appropriate. And I find no reason, sir, that you should disturb your ruling in relation to that. They have spoken about estoppel. Estoppel, and my learned friend, Tricia, and her team talk about the High Trees case, sir. You cannot, sir, ask for equity when you have not done equity, and that's the crux of the High Trees case. That is the crux of that classic case, the High Trees case, and they know that full well, sir. So, the balance of justice, sir. In determining the balance of justice and convenience, it is our submission, sir, that the Commission has to also consider the parties who are before it. Sir, you would have seen the parties. You would have assessed the evidence. You would have seen that on one side, sir, you have the Barbados Light and Power with tremendous legal resources, tremendous expert resources. And on this side, sir, you have interveners who are unpaid generally, who don't have that type of resource, who do not even have the time, but they make the sacrifice, sir. When you look at the balance of convenience in this, you will see that where the balance lies. Public counsel, sir, is an example of that. We represent the most vulnerable in our society. We have assisted the Barbados Association of Retired Persons, sir. These represent the most vulnerable who are living on the edge of subsistence. They expect, sir, a fair and reasonable rate. They also expect, sir, that if catastrophe comes, that they will not be deprived of their service, because many of them, sir, rely on this. There's no alternative, sir. They cannot even, probably most of them cannot afford photovoltaic and those type of things that are now very fashionable. They're very expensive as well, sir. So we have no choice. My clients have no choice. And that's why we're appealing to you, sir. Do not disturb your decision. It is a fair and just decision. There's finality in your decision. It engenders confidence. We are looking to you, sir. Sir, there's another point that I would like to make. I know that time is limited, but this is the point. When they made their application, sir, they were duty-bound to submit a tessier. Just like in a court, when you're making your case, you are duty-bound to put the evidence, because if you're alleging something, you have to prove it. And this is the civil standard, balance of probabilities. They submitted a tessier, as far as I understand, sir. But the tessier that they submitted, they ought to have known, sir, They had the best resources, the best legal resources, the best expert resources, sir. They ought to have known that, that the year that they submitted, sir, was not a usual year. It was not by any stretch of the imagination. It was a worldwide phenomenon. It was not a usual one. They rise or fall by the evidence that they present. They cannot come now, sir, and say, well, look, let us look at something different than this thing, because it would be analogous to having two bites at the cherry, sir. And that is not permitted. It offends against this rule of finality. They know that, sir. Sir, you're in a unique position because you are being asked to review yourself, to review your decisions. Most courts don't have that luxury of reviewing themselves. They reviewing the decision. It goes up a tier to a court of appeal or whatever, sir. And sir, this hearing today is not really to look at the merits of the case itself again. It is really, sir, to see whether they have crossed that threshold. And that is why, sir, you started out by saying today is not to re-argue the case, but it's to see whether they have crossed that threshold. They can convince you, sir, on the balance of probabilities that you ought to review. My submission, sir, they have failed. Where is the new evidence that could not have been discovered? Where is it? What have they put on the table, sir, for you to consider that was not readily available or even available with prudent counsel? Expert witnesses, sir. Where is it? They have failed to produce it, sir, and therefore all the interveners' arguments, sir, wouldn't even have to be considered if they don't pass the threshold. They have to establish a prima facie case to be able to get to the next level. They have to show that you were blatantly, plainly wrong. They can't do it, sir, on the facts, because you exercise your discretion, sir, with the facts. And as I said, superior courts are reluctant because that is your discretion, sir. You're asking you to look back at the facts that you find. How logical is that? They can't do it on the law, sir. They have made a contribution to a contradiction to today, sir. I didn't prepare that, but I listened carefully and I heard it. They are talking about the storage device, sir. And they have pronounced that, you know, look at that. But how come they are saying that you can look at the storage device, but you can't look at the SIF? Or you ought not to have interfered in the SIF? The storage device mechanism is said to build in stability in the grid, sir. It helps them to stabilize the grid in light of the green energy policy and the fact that photovoltaic will come on stream and they might have, I don't want to use any technical language, but they might have disruptions or interference in terms of waves, sine waves and that sort of thing. Maybe that's technical. They're saying that that's an asset. The consumers, of course, has an interest in that. Because this is an asset that can stabilize the grid, we are concerned, we are interested in that because it will stabilize and mean that we will have an undisrupted service. Sir, how come we can look at that and that's what they're suggesting, but don't look at the SIF? It is at war with itself, sir. Their case is at war with itself. And when you find that the applicant's case is at war with itself, what do you do as an adjudicating body, sir? It means that they have not gotten themselves together. It means that they have not proven their case. It means that they have contradicted themselves in material particular, sir. And I'm asking you to do not disturb your decision. They are alleging, sir, that you have breached the right to procedural fairness by alleging that the applicant, that Yes, the applicant contends that the commission breached the applicant's right to procedural fairness by alleging that the applicant has not been transparent in its provision of evidence without stating what evidence provided by the applicant was opaque or inconsistent or demonstrated material inconsistencies. We submit, sir, that the commission give reasons. Look at the decision, sir. I came into this office a week ago. I got your decision. I started to read it, and I read it. And I was looking to see, sir, where you have not given reasons for your decisions. You have given reasons for your decisions, sir. They might not agree with the reasons that you have given for your decisions, sir. And, sir, remind them that this process is not because you feel aggrieved by a decision. You can't do this because you feel aggrieved by a decision. There must be grounds. Otherwise, you will have these type of matters going on and on and on, offending against the rule of finality. Because you disagree with a decision, you are going to come and ask them to review their decision? No, sir. That is not the way it goes. It can amount to an abusive process. They have the right to do it, sir, but they have to come with grounds. And they have not adduced any, sir. So we are contending, sir, that you have followed the rules of natural justice. The two basic rules, sir. Two basic rules. They're expressed in Latin. You hear the other side, sir. And everybody should be given a hearing to express themselves. You have done that. And everybody's fair and equal before in their arguments. Sir, you have followed the rules of natural justice. If, sir, you have not followed the rules of natural justice during the hearing, they had a right, sir. They had a right to get up and to object. They had, from my reading, sir, I am seeing no objections. I am seeing no objections to your procedure. I did not see any, sir. They acquiesced, not in a breach of natural justice because there was none, but they sat idly by. And now they come at the last minute, the 12 hours, sir, to criticize, to ask you to deconstruct your decision, which I find is a proper decision. Sir, I thank you. Unless I may be of further assistance, thank you very much.
Okay, thank you, Public Counsel. And we will now take our lunch break, and when we return, we would hear the presentation from the Barbados Association of Retired Persons. That is Douglas Skeet, and you will also be assisted by Public Counsel. Okay, so we will reconvene in 1 hour.